in the healthcare industry. I am truly honored by my colleagues' presence, along with our esteemed witnesses on the second panel. I'd like to extend an especially warm welcome to my counterpart on the Senate Antitrust Subcommittee, Senator Klobuchar, who has been a real leader on these issues. I also want to extend a warm welcome to Senators Blumenthal, Senator Cornyn, and Senator Grassley, and thank them for all of their work to lower prescription drug costs and on several of the bills under discussion today. And of course, we may have to move the order around depending on the schedule of the senators. It's also a pleasure to welcome Senator Lee, the ranking member of the Senate Antitrust Subcommittee. And finally, I am very pleased to be joined today by our colleague in the House, Chairwoman Maloney, who has led a serious and effective investigation into drug prices as the chair of the Committee on Oversight. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of today's hearing. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also like to remind all members and our witnesses that guidance from the Office of the Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings. I expect all members on both sides of the aisle to wear a mask for the duration of today's hearing. I now recognize myself for an opening statement. Prior to the onset of the COVID-19 pandemic, our healthcare system was in a state of crisis. The cost of prescription medicine has increased by 200% in a short period of time, while Kaiser Health reported that a quarter of cancer patients in the United States could not afford their medicine, so they had resorted to cutting their pills in half or skipping drug treatment entirely. Despite decades of rising costs, the United States ranked dead last in health outcomes among similar countries. In the wake of the pandemic, the healthcare sector has undergone a wave of consolidation across the entire industry, and all the while, the cost of healthcare continues to skyrocket. In the second half of 2020, there were 5 mega mergers in the pharmaceutical marketplace alone, adding up to nearly $100 billion. Within the decade, the Centers for Medicare and Medicaid Services projects that spending on healthcare in the United States will surpass $6 trillion, equal to nearly 20% of the U.S. gross domestic product. Despite ample evidence of rising costs and anti-competitive conduct in the pharmaceutical sector, the FTC has not attempted to block any of these deals, including the combination of Pfizer and Mylan's generic drug business into what is now the largest manufacturer of generics in the world. As then Commissioner Chopra and Acting Chair Rebecca Kelly-Slaughter noted in a dissenting statement, there has not been a single instance in recent history where the agency has filed a complaint in federal court seeking to halt a prescription drug merger. Under the leadership of Acting Chair Slaughter, the FTC recently launched an international working group to rethink the FTC's approach, which is a very promising step. In hospital markets, the FTC has been more active in seeking to block mergers, but the time and expense of bringing these cases over the past few years have stretched the FTC's razor-thin resources to the breaking point. At the same time, executive compensation at healthcare firms continues to soar. The CEO of Tenet Healthcare, a for-profit hospital giant with $399 million in profit last year, was paid $16.7 million in the same year that the company furloughed about 11,000 workers and received hundreds of millions in bailout funds. And according to reports by the Washington Post, Genesis Healthcare, one of the largest nursing home chains in the country, rewarded its CEO with a multi-million-dollar bonus despite shortages of medical equipment for workers at their facilities and a higher COVID mortality rate than its major competitors. Finally, the New York Times reported earlier this week that the CEO of a chain of primary care physicians was paid $199 million last year alone. In other words, we are not seeing better care or more innovation as a result of consolidation and anti-competitive practices in the healthcare sector. It is far more likely that monopoly profits are contributing to a CEO's mega yacht rather than bringing new life-saving drugs to market. As our nation recovers from both the public health and economic effects of the pandemic, it is more essential than ever that we take these issues head on. Our competition system is the backbone of promoting open and fair markets, and that is especially true here. In the pharmaceutical marketplace, the entry of generic drug competitors can reduce the cost of branded drugs exponentially. In hospital and healthcare insurance markets, competition not only lowers prices, it also improves the quality, availability, and affordability of care. But in far too many cases, effective antitrust enforcement takes too long to deliver meaningful results to people in need. For example, some branded drug companies have abused safety protocols to delay generic entry, preserving their monopoly power for more than a decade. As Professor Robin Feldman has noted, even months of delay could be worth hundreds of millions of dollars in additional monopoly revenues as the generic sits on the sideline. While these anti-competitive conduct should violate the antitrust laws, even successful cases often take too long to provide effective relief. In response to this crisis, we enacted the CREATES Act in December 2019, legislation I introduced with Senator Leahy that will lower drug prices by billions of dollars. This law will help end the abuse of the FDA's safety protocols by branded drug companies and spur the entry of numerous lower-cost alternatives. According to a recent report by the FDA, the CREATES Act has already increased generic and biosimilar competition to lower drug prices and simplify the process for market entry. In the final days of the 116th Congress, we also enacted the Competitive Health Insurance Act, legislation that repeals a long-standing exemption for the business of health insurance that has been on the books since 1945. This Congress, we plan to build on these successes by moving legislation to address other forms of anti-competitive conduct and promote competition to healthcare markets. Yesterday, I reintroduced the Affordable Prescriptions for Patients Through Competition Act, together with Subcommittee Ranking Member Buck and Senators Cornyn and Blumenthal. This legislation addresses product hopping, a particularly abusive form of conduct used by drug manufacturers to extend their monopolies by preemptively switching the market for a drug prior to the expiration of a patent. As the National Institute for Health has noted, there is often little or no therapeutic advantage for this switch. It only exists to block competitors from entering the market. For example, several years ago, the pharmaceutical company activists attempted to remove its blockbuster treatment for Alzheimer's disease and replace it with a, quote, new and improved, end quote, version in order to extend its monopoly until 2029. The new version was simply a once daily dose instead of a twice daily dose, which may be helpful but does not warrant decades of additional exclusivity. This is not true innovation and is costing hardworking Americans. According to a recent report by Matrix Global Advisors, just 5 instances of product hopping alone cost working Americans $4.7 billion annually. My distinguished colleagues on the first panel will discuss several other proposals that address additional abusive conduct, from pay-for-delay agreements to citizen petition abuse. As Chairwoman Maloney will testify today, her committee's drug pricing investigation uncovered new evidence of anti-competitive conduct, underscoring the urgency for congressional action. In closing, the American people deserve a government that is in their corner, fighting for them to take on drug profiteering and other barriers to affordable health care. Since the beginning of the 116th Congress, ending this moral crisis has been a top priority of mine as chairman of the subcommittee, a top priority for House Democrats to keep our promise to the American people to lower the health care costs. With that, it is my pleasure now to recognize the ranking member of the subcommittee, Mr. Buck, for the purposes of making an opening statement. Mr. Buck, you may still be on mute.
Does that work?
It does indeed.
I wanted to assure the chair that I am going to go maskless, and I am socially distanced approximately 1,400 miles away from Capitol Hill at this point. So I appreciate the chair's indulgence. Today's hearing focuses on the issues that are important to every American. Healthcare is a very large and important sector of our economy. It accounts for almost 1/5 of the United States GDP. According to the Centers for Medicare and Medicaid Services, America spends almost $3.8 trillion, or almost $12,000 per person, on healthcare. These sky-high costs are the result of many factors, including the misguided Obamacare legislation, a patchwork of often contradictory and burdensome federal and state laws, and anti-competitive conduct by a host of actors in the healthcare sector, but especially the pharmaceutical industry. I want to start by thanking our witnesses today. It is always a pleasure to interact with our Senate colleagues and see the bipartisan nature of the legislation we will be considering in the future. I also want to thank Chairman Cicilline for arranging this hearing, and my friend from Colorado, Congressman Joe Neguse, for highlighting abuses in the pharmaceutical industry and finding ways to lower drug costs for consumers. Obamacare was sold to the American people as a means to make healthcare affordable and protect patients. Over the past decade, the exact opposite has materialized. Obamacare has resulted in the loss of doctors and insurance options, skyrocketing costs, and increasing consolidation and monopolization of insurance and hospital markets across the country. As we heard in Martin Gaynor's testimony before this subcommittee last Congress, The two largest insurers have 70% of the market and over 1/2 of all local insurance markets. There have been almost 1,600 hospital mergers over the past 2 decades, and there were nearly 31,000 physician practice acquisitions by hospitals from 2008 to 2012, and at least 1/3 of all doctors are now in hospital-owned practices. One particularly pernicious result of this failed law is the consolidation and closing of hospitals, especially in rural areas. This leaves people in rural America, like most of the people in my home district, with few options other than driving to facilities that are often hours away. A second factor that's driving up prices, destroying competition, and leaving patients with fewer choices is the web of inconsistent and often contradictory federal and state laws and regulations. We all know the federal system is a virtually unnavigable morass of laws, regulations, and guidance documents, but this seems to increasingly be the case at the state level as well. The pandemic has shown the need for a more nimble and responsive healthcare system. That is not what we have at either the federal or state level. Instead, we have an ossified system that seemingly can't get out of its own way. For example, the Trump administration took critical steps to cut red tape and allow companies to develop extremely effective and safe vaccines to stop the pandemic in under 1 year. This previously unheard of timeline highlights the need for permanent regulatory reform, as promising drugs for other diseases like cancer, cystic fibrosis, and multiple sclerosis continue to languish for years in the bureaucratic approval process. Further, many of the largest players use this regulatory framework to stifle smaller competitors who rely on getting new medications to market to become profitable and remain in business. These smaller companies frequently end up bought by giant competitors because they do not have the funds to survive a decade-long FDA approval process. Lastly, and probably more egregiously in terms of driving up costs and decreasing patient options, are the examples of anti-competitive conduct and abuse of government process we have seen from pharmaceutical industry. The 3 bills we are considering today will result in more competition and lower prices for patients. I want to thank Senators Grassley, Cornyn, Klobuchar, and Blumenthal for their work on these important issues and for being here today to discuss these bills. In summary, the bills we are looking at today authorize regulators to investigate the abuse of citizen petitions, which artificially delay the entry of generic competitors, curb the practice of using anti-competitive pay-for-delay tactics that artificially inflate prices for patients, and stop the brand name pharmaceuticals from playing games with their patients to extend the period of their monopoly while destroying the market for generics. These bills address the gamesmanship and abusive process we have seen in this market. They will help curb the price increases and provide more options to the American consumer. In sum, the underlying issue in each of these markets is the lack of competition and anti-competitive conduct exhibited by the biggest players. Our healthcare system is based on markets, and the system only works as well as the markets that underpin it. Mr. Chair, I am proud to co-sponsor these 3 bills with you that will result in more competition, lower prices, and greater choice for patients. I yield back.
Thank you to the ranking member. I now recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for an opening statement.
Thank you. The Judiciary Committee has a strong bipartisan tradition of promoting competition in healthcare markets. We have done this vital work to make healthcare services, particularly prescription drugs, more affordable for patients. We continue that tradition with today's hearing, which will examine anti-competitive practices in this market, along with legislation to address it. I am pleased that we are joined by our distinguished colleagues from the Senate, and I thank them for their hard work on a bipartisan basis on the important legislation we introduced yesterday to lower prescription drug costs. And I want to take this opportunity to congratulate Senator Klobuchar on her new book, Antitrust, and to wish her well on its sales. All of these bills are essential to help stop pharmaceutical companies from engaging in anti-competitive conduct, such as so-called pay-for-delay agreements, citizen petition abuse, and product hopping. This conduct blocks or delays access to affordable medications without any offsetting benefits. I also want to extend a warm welcome to Chairwoman Maloney, who has led one of the most comprehensive and in-depth investigations of drug prices in congressional history as chair of the Oversight and Reform Committee. The investigation, which was originally launched by our late colleague, Chairman Elijah Cummings, has already uncovered significant new evidence of pharmaceutical companies exploiting their market power at every turn, all at the expense of the patient. Today, 1/4 of Americans report that it is difficult to afford their medicines. In fact, exorbitant medical bills are one of the major causes of why Americans seek bankruptcy relief. It is painfully clear that the soaring cost of healthcare is also bad for the health and well-being of American families. It is unacceptable that many seniors cannot afford the arthritis medication they need to perform everyday tasks, such as buttoning their coats or opening a jar without excruciating pain. It is unacceptable that hundreds of thousands of cancer patients are reportedly delaying life-saving care, cutting their pills in half, or skipping treatment entirely because of high drug prices. And it is unacceptable that people suffering from diabetes must worry about life-threatening consequences of not being able to afford insulin because of its exorbitant cost. These trends have only worsened in the wake of the pandemic, which has wrought tremendous economic hardship in our communities. It's time for this to change. As many experts have noted, including some of the witnesses who will testify here today, the lack of competition in healthcare markets is one of the primary causes of escalating costs. In recent years, under Republican and Democratic leadership, the subcommittee has held numerous hearings in this area, examining the topics of consolidation in the market for health insurance, competition in the drug supply chain, and anti-competitive practices by prescription drug companies. I am pleased that we're continuing that essential work today. One focus of our efforts should be lowering prescription drug costs by strengthening competition from lower-priced generic drugs. According to the Federal Trade Commission, the first generic competitor to a branded product is typically offered at a price 20 to 30% below the brand price. Subsequent generic entry creates greater price competition, with price drops reaching 85% or more off the brand price. In response to the threat of generic entry, which of course threatens the ability of branded drug companies to charge monopoly prices, branded companies have engaged in numerous anti-competitive tactics. This committee has been and will continue to be active in stopping drug companies from reaping monopoly profits at the expense of patients' health. For example, I am proud to have reintroduced the Preserve Access to Affordable Generics and Biosimilars Act with Senator Klobuchar, Chairman Cicilline, and Ranking Member Buck to ban so-called pay-for-delay settlements. These anti-competitive agreements allow branded drug companies to pay off a generic competitor to delay entering the market with a lower-cost generic product. As a result of this abusive conduct, the brand name drug company gets to keep its monopoly, and the generic gets paid off with a portion of the monopoly profits, but the consumers inevitably lose. Although the Supreme Court in FTC versus activists held that pay-for-delay agreements could violate the antitrust laws, the FTC expends significant resources challenging what appear to be clear violations. This legislation would address that problem by requiring courts to view such agreements as presumptively unlawful. According to the nonpartisan Congressional Budget Office, this legislation would save American taxpayers at least hundreds of millions of dollars over 10 years due to the high costs imposed on our healthcare system by this anti-competitive conduct. I was pleased that this legislation passed unanimously out of the committee in the last Congress with strong support from then Ranking Member Collins. I hope it will receive similar support from my colleagues on the committee in this Congress. I also look forward to addressing this issue together with our colleagues on the Energy and Commerce Committee in the weeks ahead. In closing, I thank the chairman for holding today's important hearing, and I welcome all of our esteemed colleagues and panelists. I look forward to hearing their testimony, and I yield back the balance of my time.
Thank you, Mr. Chairman. It is now my pleasure to introduce the witnesses for our first panel. Our first witness is the Senior Senator from Minnesota and Chair of the Senate Judiciary Subcommittee on Competition Policy, Antitrust, and Consumer Rights, Amy Klobuchar, and soon to be an award-winning author. Additionally, Senator Klobuchar is Chair of the Senate Democratic Steering and Outreach Committee, as well as the Rules and Administration Committee. She has served Minnesota for more than 20 years, first as the Hennepin County Attorney from 1998 to 2006, and since as a United States Senator. Prior to entering public service, Chairwoman Klobuchar was a partner at both Dorsey & Whitney and Gray Plant & Moody, specializing in regulatory work in the areas of telecommunications. Chairwoman Klobuchar received her bachelor's degree from Yale University and her JD from the University of Chicago Law School. Today's second witness is Senator Charles Grassley, former chairman of the Senate Judiciary Committee, president pro tem of the Senate, and senior senator from Iowa. Additionally, Mr. Grassley has chaired the Senate Finance, Narcotics, and Aging Committees in his 4 decades in the United States Senate. Prior to being elected to the Senate in 1980, Mr. Grassley served in the Iowa House of Representatives from 1959 to 1975, and the United States House of Representatives from 1975 to 1980. Before entering public service, Mr. Grassley worked farms and on factory floors in Iowa, first as a sheet metal shearer and then as an assembly line worker. Mr. Grassley received both his bachelor's and master's degrees from the University of Northern Iowa. Our third witness is a senior senator from the state of Connecticut, Richard Blumenthal. He was elected in 2010 and is currently serving his 2nd term. Prior to his election to the Senate, Mr. Blumenthal served Connecticut as Attorney General for 20 years, from 1991 to 2011, the longest tenure in the state's history. As a state senator from 1987 to 1991, in the Connecticut House from 1984 to 1987, and as United States Attorney for the District of Connecticut from 1977 to 1981. He is also a 6-year veteran of the United States Marine Corps Reserves, where he attained the rank of sergeant. Mr. Blumenthal received his bachelor's degree from Harvard College and his JD from Yale Law School. Our fourth witness, Senator John Cornyn, is chairman of the Senate Judiciary Committee on Border Security and Immigration and the senior senator from the state of Texas. Senator Cornyn is currently serving his 4th term and was first elected to the Senate in 2002. He has served the state of Texas in a number of elected positions, including as Bexar County District Judge, Texas Supreme Court, and Texas Attorney General. In the 114th, 115th, and 116th Congresses, Mr. Cornyn served as the Senate Majority Whip. Senator Cornyn received his bachelor's degree from Trinity University, his JD from St. Mary's Law School, and his master's of laws from the University of Virginia. Our fifth witness, Senator Mike Lee, is the ranking member of the Senate Judiciary Subcommittee on Antitrust, Competition and Policy and Consumer Rights, and the senior senator from Utah. Mr. Lee is also the ranking member of the Joint Economic Committee. He was elected to the Senate in 2010 and is currently serving his 3rd term. He spent years with the law firm Sidley & Austin as an attorney specializing in appellate and Supreme Court litigation, and then as Assistant United States Attorney in Salt Lake City. He has clerked for Supreme Court Justices Samuel Alito on both the U.S. Court of Appeals, 3rd Circuit, and on the Supreme Court. Mr. Lee received both his bachelor's degree and his JD from Brigham Young University. The final witness on our first panel is my distinguished colleague, the chair of the House Committee on Oversight and Government Reform, Carolyn Maloney. Chairwoman Maloney has represented New York's 12th district since 1992 and has served as chair of the Committee on Oversight and Government Reform since 2019. A lifelong public servant, she worked for the people of her state at the New York City Board of Education, then in the New York State Legislature. In 1982, Chairwoman Maloney was elected to the New York City Council, where she served for 10 years until her election to Congress. She has also served at various times as vice chair of the Joint Economic Committee, regional whip of the Democratic Caucus, and the vice chair of the House Democratic Steering and Policy Committee. Chairwoman Maloney received her bachelor's degree from Greensboro College. We welcome all of our very distinguished witnesses on our first panel, and we thank them for their participation. I will ask the witnesses to summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light in WebEx. When the light switches from green to yellow, you'll have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes have expired, and of course, your full written testimony will be made a part of the record. And with that, I now recognize the distinguished senator from Minnesota, Senator Klobuchar, for 5 minutes.
Well, thank you very much, Mr. Chair, Ranking Member. I assure you, Mr. Chair, if they ever make a movie out of my book, Dream On, you will have a starring role. Thank you for your work on digital platforms, the bipartisan work in this committee, and this incredible gathering you've put together to make the point that it's not just tech where we see this kind of consolidation. It's healthcare. It is everything from cat food to caskets. So I got involved on the pharma side when I got a call in 2008 from a pharmacist at Minneapolis Children's Hospital who said, you know, this price of this life-saving drug for heart defects for kids, babies, newborn babies, has gone up from $85 a treatment to $1,600 a treatment. I'm thinking, that's impossible. I call the head of the hospital, I start looking into it. What happened was one company bought that drug, and then they cornered the market. They bought the other drug, and those were the only 2 drugs available, and they went to town and made a whole bunch of money. Even the FTC, they tried to take it on. We tried to take it on in Congress, AGs across the country tried to take it on. They ultimately failed, and it took years for a generic to develop. That is what we're dealing with. When newborn babies and their parents and all the hospitals in the country can't win a case, we better do something about it. And I think you know some of the answers because they've come right out of this House. First of all, I would suggest negotiation of drug prices under Medicare, bill that I lead, as well as Representative Welch. I think it's a great idea. President mentioned it last night. Doing something when it comes to drug reimportation, something that I know Chairman, many people have worked on over on this side. I also have worked on that bill with Senator Grassley. I know he's coming up next. That's a pretty important effort, and there's efforts over here as well. Protecting drug price competition and doing something about generics. You mentioned the CREATES Act and the work we have to do to stop pay for delay. That is ripe for action. It is outrageous that we still have this practice going on where pharmaceuticals are paying their competitors, generics, to keep their products off the market, and there is more we can do on that, and you mentioned a few of those efforts, Mr. Chairman. Finally, antitrust competition policy. Incredible consolidation that's been going on, and I'm focused here, there's other aspects of healthcare, but on pharma. And what I'm thinking is when you look at what we're dealing with, when we've got the biggest companies the world has ever known in Facebook and Google now being sued by the FTC and by the Justice Department, this was a good thing. I'm glad that Macon Delrahim and Chairman Simons under the Trump administration brought these suits. Now they're being carried on by the Biden administration. But you can't just do that and expect these healthcare pharma issues to be taken care of without funding those agencies. And Senator Grassley and I, he can mention this, have a bill to finally update our nation's antitrust laws fees when it comes to mergers. It's a merger filing fee bill. Almost got on, as you know, Mr. Chairman, at the end of the year in the budget with support from the White House. We need to get that done immediately. And that will add significant resources to the two agencies, plus the appropriations policies. You cannot take on big pharma and big tech with Band-Aids and duct tape. You have got to give them the resources to do it. And then I would finally add the work we're all doing on going after exclusionary conduct, going after these mergers, changing the standards, and making sure that our laws are sophisticated as the companies that are supposed to be serving consumers. Thank you, Mr. Chair.
Thank you, Senator. I now recognize the distinguished senator from Iowa, Senator Grassley, for 5 minutes.
Thank you very much for the invitation, Mr. Chairman. Millions of Americans started their day with a dose of prescription medication. Unfortunately, for many patients, those drugs aren't affordable. Prescriptions are left at the pharmacy counter, and doses are skipped or rationed until the next paycheck. That is unacceptable. As chairman of the Finance Committee last Congress, I explored several approaches to reduce healthcare costs. Senator Wyden and I started by investigating insulin pricing. We found that the business practices and competitive relationships between manufacturers and middlemen, the pharmacy benefit managers or PBMs, whatever you want to call them, have created a vicious cycle of price increases. PBMs spur drug makers to hike list prices in order to secure prime formulary placement and greater rebates. I also investigated the debt collection practices of nonprofit hospitals. I examined how these hospitals make financial assistance plans available to patients, and the patients can't even afford to pay. Nonprofit hospitals enjoy certain tax benefits because they're supposed to serve the needs of their communities and particularly patients with limited means. It's only fair that we ensure compliance with the laws if they get special treatment. I've worked with Senator Wyden on prescription drug bill that would lower drug costs and, at the same time, save the taxpayers $95 billion. Our bill would cap out-of-pocket drug costs for seniors at $3,100. It would slow the growth of drug costs in the future while protecting innovation by keeping government out of the business of setting prices. The key part of the bill limits year-over-year increases to CPI, or approximately 2% today, as opposed to the usual increases of 5 to 10% every year. It's the only prescription drug bill that can get 60 votes in the United States Senate. I also believe that the importation of safe and affordable prescription drugs from Canada would lower healthcare costs. As you heard, Senator Klobuchar and I worked together on several bills, so we have a bill to allow this, creating savings for consumers and injecting more competition into the pharmaceutical market. When I chaired the Judiciary Committee, I conducted an investigation into EpiPen's misclassification in the Medicaid drug rebate program. My investigation started when a constituent contacted me about high EpiPen costs. Those constituent contacts and its resulting congressional investigation ultimately contributed to the implementation of the bipartisan bill that we call the Right Rebate Act. We must deter companies from engaging in activities that aim to reduce competition, including regulatory interference, pay for delay, product hopping, and rebate bundling, just to name a few. Again, Senator Klobuchar and I reintroduced our bill to combat anti-competitive pay for delay deals, where brand drug companies pay their generic competitors not to compete. Klobuchar and I also reintroduced our bill to reduce the incentives for brand drug companies to interfere with the regulatory approval of generics and biosimilars that would compete with their own products. The largest PBMs have merged with insurance companies, and these conglomerates often own other players in the healthcare industry. It's important to determine whether consolidation helps patients or, as I believe, creates anti-competitive behavior and increased costs. I've also introduced a bill with Senator Cantwell to bring transparency to the PBM industry by requiring the Federal Trade Commission to study the effects of consolidation on pricing and potential anti-competitive behavior. Further, Congress should codify regulations requiring hospitals and insurers to disclose their low discounted cash prices and negotiated rates to consumers before they receive medical care. We should pass Senator Braun's Price Transparency Act, which I co-sponsored. We should work in a bipartisan, bicameral fashion to tackle the problems of rising healthcare costs, and this hearing proves in a bicameral way that we're doing it. Thank you again for the opportunity to testify.
Thank you very much, Senator Grassley. I now recognize Senator Blumenthal, the distinguished senator from the state of Connecticut, for 5 minutes.
Thanks so much, Mr. Chairman. And I want to begin by really very enthusiastically thanking you for your leadership on antitrust issues, what you and the committee have done, along with the other members, on the tech monopoly and predatory pricing and conduct issues is truly remarkable. And I'm sure that you will be doing the same here. And I'm proud to be a co-sponsor with you of many of the measures that are coming before the committee today. And I just want to say how honored I am to join in sponsoring the No Stalling Act and to support the Preserve Access to Affordable Generics and Biosimilars Act, led by Senator Klobuchar. Speaking of Senator Klobuchar, here's the book. Buy it. It's a big book, serious, but as the title indicates, it covers taking on monopoly power from the Gilded Age to the digital age. Now, in the Gilded Age, as you know, they divided up territory and they fixed prices in smoke-filled rooms. The means now of monopoly and predatory conduct are much more sophisticated and less visible because we live in a digital age. But the effects are a matter of life and death. And I am very much in favor of the conduct remedies or misconduct remedies, the behavioral standards that we're going to hopefully write into law, including importing more drugs, requiring negotiation of Medicare pricing, other kinds of steps. And one of them, by the way, is the Bipartisan Affordable Prescription for Patents Act, which I've joined with Senator Cornyn on co-sponsoring. But at the end of the day, what's really needed here is a structural remedy. Break them up. That's the remedy that I've advocated on some of the big tech companies. Break them up. They've grown too big. It's given them monopoly power. They are misusing that power. I know what it's like to sue based on antitrust law, a monopolistic predatory power. I did it as Attorney General against Microsoft, and it had an enormously important positive effect for consumers. So I respectfully suggest that we need stronger enforcement of the laws we have. We also need to enhance and improve the laws with regard to our power of enforcement and provide more resources to the enforcers in the FTC, in the Department of Justice. They need to be empowered to enforce the law more aggressively and effectively. We've seen too little of it in past years. Let me just say about the Bipartisan Affordable Prescription for Patients Act. I thank Senator Cornyn for sponsoring this bill. It would eliminate the abuses of product hopping, which, for example, was demonstrated by activists when it feared that its patent would run out on an Alzheimer's disease. And instead of facing the fact that it would no longer have exclusivity, it issued a new product, supposedly, but really it was the old product with an extended release mechanism. And it pulled the old drug from the market, and it was able to continue charging monopoly prices as a result. This kind of practice is used with respect to countless drugs. They inflate prices, they deprive people of life-saving medication. And I am also pleased to be in partnership with Representatives Johnson and Issa in a House companion to a bill that shuts down the abuses of the patent dance. Product hopping, patent dance, they have colorful names, but they are abhorrent to consumers. Patent dancing involves, in effect, resolving patent litigation quickly before a biosimilar is introduced on the market, which creates a patent dispute resolution process and enables the manufacturer to continue with a lock on the market. So I recommend tougher, more aggressive enforcement, structural remedies, but in the meantime, these kinds of efforts to eliminate abuses of monopolistic power must be advanced. I thank you, Mr. Chairman, and I yield.
Thank you very much, Senator Blumenthal. And now I recognize Senator Cornyn, who is the co-lead in the Affordable Prescription for Patients Act, along with Senator Blumenthal, Ranking Member Buck, and myself. Welcome to the committee. You're now recognized for 5 minutes.
Well, thank you, Chairman Cicilline and Ranking Member Buck and members of the subcommittee. It's unusual to have this many members of the Senate testifying in the House, but we're grateful for your invitation and the opportunity. After more than a year battling COVID-19, the light at the end of the tunnel is rapidly growing brighter and larger because of the astonishing scientific achievements that led to multiple effective vaccines. As you know, more than half of the adults in America have received at least one dose, and I look forward to the time when this vaccine helps put this virus to bed once and for all. I say this because it's important to recognize that American ingenuity, creativity, and innovation are remarkable qualities that has led to life-saving discoveries. But alongside this innovation, we also have to have smart public policies that protect both the creators and the beneficiaries of these discoveries. And there's no better example than prescription drug prices. As the cost of many prescription drugs have skyrocketed in recent years, countless of my constituents in Texas have reached out to share stories about the impossible decisions their families have had to make, which have only become more heart-wrenching over the last year. Not paying some of their bills, cutting pills in half, skipping doses, or not filling prescriptions altogether because they're simply too expensive. No family should have to make these types of difficult choices. That's why Senator Blumenthal and I have offered up the Affordable Prescriptions for Patients Act in the Senate, and we've been proud to work with a bipartisan group of colleagues on both sides of the Capitol. And the strong bipartisan bicameral support for this bill demonstrates just how common sense these reforms are. Now, I know most of us haven't heard the terms of product hopping or patent thicketing in the past, but as you heard from Senator Blumenthal, this is the core of the problem that this bill attempts to solve. Product hopping occurs when a company develops a reformulation of a product that is about to lose its patent exclusivity and then pulls the original product off the market. This isn't done because the new formula is more effective, but because it prevents generic competition. This simply needs to stop. The FTC should be able to bring antitrust suits against bad actors who deliberately game the patent system, and this legislation will ensure that that's possible. Second is patent thicketing. This occurs when an innovator uses multiple overlapping patents with identical claims to make it nearly impossible for competitors to come to market. This abuse of the patent system comes at a high cost for patients. To solve this, our legislation would streamline the way drug manufacturers resolve patent disputes so lengthy legal processes don't stand in the way of competition. We're protecting patent rights, which are critical, but we're not letting these important issues get bogged down in the sludge of time-consuming and expensive legislation. We know companies are unlikely to pour extensive time, money, and resources into discovering new cures if at the end of it, they can't recoup their costs. But we can't allow bad actors to abuse the system for their financial gain either. We know that there's bipartisan support for this bill, as I said, on both ends of the Capitol. I hope we can achieve the same success we did last year when this bill passed with bipartisan support, unanimous support in both the House and Senate Judiciary committees. So I'm proud to be here with my colleagues, Senator Blumenthal, to advocate for these proposals, and we look forward to working with all of you to bring down drug prices for American families.
Thank you very much, Senator Cornyn. I now recognize Senator Lee for 5 minutes. I believe is on the screen.
Thank you very much. Thank you, Mr. Chairman and Ranking Member Buck. Esteemed members of the subcommittee, thanks to all of you for asking me to speak today. As the leading Republican on the Senate's sister subcommittee to this body over the last decade, I've developed tremendous appreciation for our country's antitrust laws and for the importance of competition policy to our national economy. Rising healthcare costs and limited healthcare options are leading concerns for Americans of all stripes, making competition in the healthcare markets particularly important. Now, I share the commitment of my colleagues who have joined you today in ensuring and protecting competition across the healthcare space. In 2016, I was honored to introduce, along with Senators Grassley, Leahy, and Klobuchar, the CREATES Act, which was finally passed by Congress and signed into law by President Trump in 2019. As you know, the CREATES Act was designed to protect competition and to lower drug costs by ensuring that generic competitors have access to samples of certain brand name drugs for the purpose of establishing bioequivalence for the FDA. The Congressional Budget Office estimated that the law will save taxpayers $3.8 billion over 10 years. And industry participants tell me that it's already improving generic competition. As this subcommittee considers additional legislation aimed at ways to improve competition across various healthcare markets, I'd urge you to follow the model that we made with the CREATES Act and that helped make the CREATES Act so successful. Light touch reform to help align private incentives to benefit competition rather than government intervention that displaces competition with regulation. We should all examine our history to find the root causes of consolidation in America's healthcare industry and tackle the issue with incremental, targeted fixes rather than a massive one-size-fits-all approach. That, in turn, will require taking a wide view of the factors that impact competition in healthcare markets, including existing federal and state laws and regulations. If there's anything worse than a monopolist using its power to squelch competition and squeeze consumers, it's when that monopolist is a creature of government policy and power. We, as elected representatives of the people, entrusted with enacting laws, hopefully in pursuit of justice and equality, we have to always be vigilant against allowing the democratic process to be corrupted, even if inadvertently, to pick winners and losers. If we want to make reforms in this area, we sadly have no shortage of opportunities. At the state level, entry into hospital markets is frequently restrained by state certificate of need laws. These laws require potential market entrants and existing competitors to obtain permission in advance from the state to build new hospitals or to expand current facilities. In some states, incumbent hospitals even have veto power over granting certificates to new entrants. This is crony capitalism, pure and simple, and patients everywhere have suffered for it where these laws have been in place. It's no wonder that the pandemic saw at least 24 states suspend or loosen their certificate of need laws. Imagine the benefits to healthcare and competition within healthcare if states just repealed those laws, which we don't need anyway, and harm people in any event. Another common restriction at the state level are limitations on nurse practitioners, some of which make little to no sense and provide little to no benefit or additional safety to the patient. The conflict of interest is obvious. For many basic needs, nurse practitioners offer comparable skill and service at a lower price. This is something that increases access to healthcare for the most economically vulnerable. So removing those sorts of restrictions would inevitably generate price and quality competition between nurse practitioners and physicians and improve costs and improve outcomes for patients across the country. This is one of those many areas in which if we just allow for people to do what they do best. Here in the case of nurse practitioners, take care of people without excessive government intervention, then we'd be better off without that intervention. Government intervention in healthcare has also had disastrous effects at the federal level. Medicare has used federal clout to strong-arm healthcare providers into agreeing to low reimbursement rates. Now, ordinarily, we should share lower prices, but in this case, the so-called savings are really just subsidies paid for by insured and by self-pay patients. So this isn't healthcare reform. It's a sort of Ponzi scheme. Medicare for all would mean that there was no one left to pay the subsidy and everyone would suffer. These artificial pricing pressures also mean that healthcare markets are not able to fully respond to competitive pressure and would have fewer resources to invest in expansion and innovation. And as a result, consumers would have fewer options. Quality would go down, prices would go up. Obamacare has had a similar effect.
Senator, if I could just ask you to conclude your testimony. You're well over your time, but I wanted to accommodate you as much as I can.
Great, thank you. So we're all familiar with the promise that if you like your plan, you can keep it. This has turned out not to be true. So it's always tempting in all this to retrench into tribalism and push for encompassing reforms, all-encompassing solutions that might only require a floor time once. Our constituents deserve better. They deserve a free market approach where providers can respond to needs and demands. Antitrust enforcement and competition policy have historically been areas of bipartisan agreement, and we know that vigorous competition is necessary. So thanks for your close attention to keeping America's healthcare markets competitive. And I thank you again for inviting me to join you today. I look forward to working with each of you.
Thank you, Senator Lee. And now, at the risk of offending our colleagues in the other chamber, we did save the best for last. Chairwoman Maloney, you're recognized for 5 minutes.
Thank you so much, Chairman Cicilline, Chairman Nadler, Ranking Member Buck, and members of the subcommittee. Thank you for holding this important hearing today and inviting me to testify about the Oversight Committee's findings of anti-competitive conduct in the pharmaceutical industry. At the onset, I want to commend this subcommittee for its groundbreaking work on antitrust issues, and also to acknowledge the historic work of my friend and colleague in the Senate, Senator Klobuchar, and her heroic work in fighting rising prescription drug prices. The former chairman of my committee, the late Elijah Cummings, cared deeply, as I do, about the issue of rising prescription drug prices. He understood that drug companies' exorbitant prices have devastated patients across our country, forcing many to make gut-wrenching choices between affording their medications and paying rent, buying food, or saving for retirement. For this reason, at the beginning of the 116th Congress, Chairman Cummings launched an in-depth investigation into some of the largest and most profitable drug companies in the world. This investigation has remained one of my highest priorities since I took over as chairwoman. Over the last 2 years, we have reviewed over 1.3 million pages of internal company documents. Last fall, the committee held hearings with 6 CEOs and released 5 staff reports summarizing our initial findings. Before I describe some of these findings, I want to recognize that we rely on the pharmaceutical industry to develop critical new therapies, cures, and vaccines. In exchange, our system grants these companies the exclusive right to sell their products for a limited number of years without facing competition from lower-priced generic and biosimilar drugs. Unfortunately, brand-name drug companies have abused this system by engaging in blatantly anti-competitive strategies to extend their monopoly pricing for far longer than our system intended. Our committee's investigation found that these strategies, combined with laws restricting Medicare's ability to negotiate directly for lower prices, have emboldened drug companies to target the United States for price increases while cutting prices in the rest of the world. Our system, in essence, is leading to higher and less affordable drug prices right here in the United States. In addition, our investigation found that pharmaceutical companies dedicate significant portions of their research budgets to coming up with new ways to suppress generic and biosimilar competition, rather than focusing on developing new therapies. By allowing these anti-competitive tactics to continue, we are paying more money and getting less innovation. Our investigation exposed the inner workings of the types of anti-competitive conduct your subcommittee is seeking to combat. Here are just a few examples. One drug company, Teva, engaged in what is known as product hopping, using its monopoly market power to shift patients from one dose of its blockbuster MS drug, Copaxone, to another dose before generic competition for the first dose comes to market. Experts estimate this one product hop cost the U.S. health system $4.3 billion. Another example, companies such as Amgen and Novartis entered into patent settlement agreements with potential generic competitors to delay their entry into the market. Amgen internally estimated that it collected $202 million in extra sales of the kidney drug Sensipar by delaying generic entry by just 10 weeks. Experts estimate that Novartis' delay of generic competition for its cancer drug, Gleevec, cost the U.S. market over $700 million. The last example I have is executives at another company, Celgene, discussed how to leverage the high price of its cancer drug, Revlimid, to prevent other competitors from conducting productive cancer research. Our committee's investigation also revealed damning details about other abuses, like patent thickets, misuse of the Orphan Drug Act, and exclusionary contracting with pharmacy benefit managers. I encourage members and the public to use these reports as a resource as they seek to combat rising drug prices in our country. I want to end by emphasizing that we are not done. My committee is continuing to investigate abuses by the pharmaceutical industry. On May 18th, the committee will hold a hearing with the CEO of AbbVie. AbbVie sells Humira, the highest grossing drug in the United States and the world. The committee has obtained internal documents, previously not public, that show that the tactics of AbbVie has used to suppress competition for Humira and other drugs and maintain monopoly pricing in the U.S. I hope the Oversight Committee's findings are helpful to the Judiciary's committees as you consider legislation to address the pharmaceutical industry's anti-competitive practices and unsustainable, unfair, deceptive price increases. Thank you. I appreciate the opportunity to appear before you today and congratulate you on all your hard work in this area. And I yield back.
I thank the gentlelady for her testimony and can assure her that the extraordinary work of your committee is very supportive of the work of this subcommittee, so we thank you. And with that, I'd like to thank each of our distinguished witnesses on our first panel for their very valuable testimony today. You are now excused, and we will hold briefly while staff will make the necessary accommodations for our second panel, which should just take a couple of minutes. should I bang the gavel? Okay, we'll come back to order. It's now my pleasure to introduce the witnesses on our second panel. Our first witness is Dr. Lee Moore Daphne. Dr. Daphne currently serves as the Bruce V. Rauner Professor of Business Administration at the Harvard Business School and Harvard Kennedy School, where she teaches courses on healthcare strategy and policy. Her research focuses on competitive interactions between payers and providers of healthcare, with a focus on antitrust competitive strategy and public policy. Dr. Daphne is a research associate of the National Bureau of Economic Research and is on the panel of health advisors to the Congressional Budget Office. From 2002 to 2013, she served as the Deputy Director for Healthcare and Antitrust at the FTC's Bureau of Economics and has been published in various journals, including the American Economic Review and the New England Journal of Medicine. Dr. Daphne received her bachelor's degree from Harvard College and her PhD from the Massachusetts Institute of Technology. The second witness on our panel is Michael Carrier, Distinguished Professor and Co-Director of the Rutgers Institute for Policy and Law. Professor Carrier has served at Rutgers since 2001 and was named Co-Director of the Institute for Information Policy and Law in 2013. He's widely published and has been featured in journals including the Chicago Law Review, the Michigan Law Review, the Columbia Law Review, and CPI Antitrust Chronicle. Professor Carrier is currently on the Board of Advisors to the American Antitrust Institute and a contributing editor for the Antitrust Law Journal. Before joining the faculty of Rutgers, Professor Carrier spent 4 years at the firm of Covington and Burling, where he focused on antitrust, intellectual property, sports, and civil litigation. Professor Carrier received his bachelor's degree from Yale University and his JD from the University of Michigan Law School. The third witness on our panel is the Arthur J. Goldberg Distinguished Professor of Law at the University of California Hastings College of Law, Professor Robin Feldman. She is also the director of the UC Hastings Center for Innovation. Professor Feldman has been published in many well-respected journals, including the New England Journal of Medicine and the Stanford Technology Law Review. She was elected to the American Law Institute in 2012 and has received both the William Rutler Award for Excellence in Teaching and the 1066 Foundation Award for Scholarship. Professor Feldman received both her bachelor's degree and her JD at Stanford University. Our last witness today is Alden Abbott, the Senior Research Fellow at George Mason University's Mercatus Center. Before joining Mercatus, Mr. Abbott served as the Federal Trade Commission's General Counsel, representing the Commission in court. He has a long career serving the federal government, the FTC, the Department of Justice, and the Department of Commerce. He's also worked at the Heritage Foundation and BlackBerry Limited. Mr. Abbott was an adjunct professor at George Mason University's Antonio Scalia Law School for almost 20 years and is widely published on matters of competition, regulation, and international trade. Mr. Abbott received his bachelor's degree from the University of Virginia, his master's in economics from Georgetown University, and his JD from Harvard Law School. We welcome all of our distinguished witnesses on our second panel, and we thank you for your participation. I will begin by swearing in our witnesses, and I ask our witnesses that are testifying in person to rise. I ask our witnesses testifying remotely to turn on their audio and make sure that we can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes to help you stay within that time frame. There's a timing light in WebEx. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes have expired. I now recognize Dr. Daphne for 5 minutes.
Chairman Cicilline, Ranking Member Buck, and distinguished members of the subcommittee, I thank you for holding this hearing and giving me the opportunity to testify on the subject of healthcare consolidation. My name is Lee Moore Daphne, and I'm an academic health economist with long-standing research interests in competition and consolidation. I'm a professor at the Harvard Business School and the Harvard Kennedy School, and I previously served as the Deputy Director for Healthcare and Antitrust in the Bureau of Economics at the Federal Trade Commission while on university leave. I'm on the panel of health advisors to the Congressional Budget Office, and I engage with regulators, policymakers, and businesses in my role as a faculty member and a healthcare antitrust expert. The United States spends a larger share of its GDP nearly 18% on healthcare than any other country. Studies show that high prices, not the type or quantity of services consumed, nor the health of our population, are the primary driver of higher US spending. International comparisons also show the US lags other leading developed countries on most dimensions of healthcare quality. We're not receiving the highest possible value for our dollars, far from it. My focus today is healthcare providers, such as hospitals and physicians, who jointly account for about half our healthcare spending. As you're aware, government programs like Medicare set prices for provider services like hospital admissions. But the private sector relies on market-based prices, and those prices are high and growing. Back in the late 90s, private prices were about 10% higher than Medicare prices. By 2012, they were 75% higher. And today, privately insured patients pay on average 2 times what Medicare pays for hospital care. These higher prices hurt patients, and they hurt our economy. As a response to high prices, health insurance premiums and deductibles are rising. High deductibles mean people pay thousands of dollars out of pocket when they are unlucky enough to require care. And higher insurance premiums mean smaller paychecks. The key questions I'm here to answer is whether consolidation is driving these higher prices and what we can do about it. My answer to the first question is yes. Studies show horizontal or same market consolidation results in higher prices for hospitals. This is also true for physician groups and for insurance premiums. The evidence on non-horizontal healthcare mergers, such as mergers across providers or firms in different geographies or service categories, also shows prices and spending increase post-merger, in particular after hospital systems acquire additional hospitals in the same state and after hospitals acquire physician practices. Antitrust enforcers regularly challenge horizontal mergers, but challenges of non-horizontal mergers are very rare, and in my recommendations, I suggest ways to enable such challenges. Let me be clear. The bad guys in healthcare are not hospitals or doctors or even insurers. The bad guy is a lack of competition driven by consolidation. The COVID pandemic has shown us what is magnificent about our healthcare providers. They rose to the occasion and did all they could to meet patients' needs. They collaborated with one another in resourceful ways. But that doesn't mean they need to merge with one another now. If the pandemic stimulates even more consolidation, we'll face a different type of long-haul symptom of COVID, higher prices. To protect competition, I have 3 recommendations. First, strengthen our federal enforcement agencies' ability to identify and review potentially anti-competitive conduct in mergers. You can do that by requiring more healthcare transactions to be reported, mandating insurers share healthcare claims data with federal agencies, and increasing agency budgets. In real terms, appropriations in 2018 were 18% lower than in 2010, and the recent increase has only kept up with inflation. Restoring and increasing funding will yield a return for years to come. Second, amend and strengthen the antitrust statutes. Ensure the statutes prohibit healthcare mergers that enable providers to exploit existing market power and are likely to harm consumers. The current wording or interpretation of that wording is enabling scores of transactions that are harmful to consumers to proceed. Third, ask the agencies to issue healthcare guidelines that set forth their interpretation of antitrust statutes in healthcare today. Regulators, private parties, and courts pay close heed to agency guidelines, so this has potential for real impact. Our healthcare providers have so many people working hard to help people live better lives. My recommendations are not aimed at making their work more difficult. They're aimed at creating a market context that brings out their best and rewards them for it. Thank you.
Thank you very much, Dr. Daphne. I now recognize Professor Carrier for 5 minutes.
Thank you very much. Drug prices are too high, and one main reason why is that brand companies play all sorts of games: product hopping, pay-for-delay settlements, citizen petitions, biosimilar, disparagement, All of these things harm consumers, and there's no justification at all based on patents or innovation. At the same time, there's more and more consolidation. The industry is getting more and more consolidated, and the FTC has responded only by requiring the divestiture of overlapping products. I think that Congress can act, it can make consumers' lives better, and it cannot touch innovation in the process. And so the CREATES Act is a great model. Chairman Cicilline, I thank you for your leadership on this important bill, which has had a significant effect. And I also wanted to tie my remarks to what Senator Lee said. Senator Lee said that we wanted a light touch reform and incremental targeted fixes. Every one of these pieces of legislation fits that bill exactly. My name is Michael Carrier. I'm a distinguished professor at Rutgers Law School. I spent my career focused on the intersection of the antitrust and the IP laws. I've written 130 articles, co-author of the leading treatise, and really spend all of my time thinking about these issues. So the first thing that Congress can do is to address product hopping. Most reformulations by drug companies are fine. Most of the time, there's innovation, there is not a pending generic. But some of these reformulations are very concerning. Some of the reformulations make no sense at all other than harming the generic. And every time that the brand company makes a tiny switch from a capsule to a tablet or just adjusting the dose a little bit, the generic cannot be substituted at the pharmacy counter. And so it has to go back to the drawing board, and consumers are stuck paying high prices. Brand companies oftentimes have no good reason for what they're doing. In the Namenda case, the brand company pulled a $1.5 billion drug from the market. In the Suboxone case, it disparaged its own product. The legislation here, H.R. 2873, would address these issues. The courts have not figured out what to do with soft switches when the old drug remains on the market. This is the best piece of legislation to deal with it. Second is pay for delay settlements. Brand companies have paid generics to delay entry. There is no good reason for this, but even though the Supreme Court and activists clearly said that this violates antitrust law, the settling parties have come up with all sorts of reasons why their agreement is not a pay for delay settlement. This piece of legislation would be very important to give the FTC power to go to court and not have to spend a decade trying to prove something that is very difficult to prove. And it also would solve some problems in the courts. Not every court gets activists right. And so that's why the legislation is so important. Third is citizen petitions. Citizen petitions are meant to raise legitimate concerns with the FDA. As it turns out, however, most of them are filed by brand companies, and the FDA denies most of them. And so H.R. 2883 would be very helpful in giving the FTC power to go after this sham-related conduct, to make clear that a series of petitions could be a sham, and to show that the penalties are significant, which would increase deterrence. Fourth is biosimilar disparagement. In the biologics industry, which is the next big wave, there's not as close a relationship between the biologic and the biosimilar as there is between the brand and the generic. So the biologic has made all sorts of claims that the biosimilar is not identical, that maybe if you take it, something bad will happen to you. The courts have not shown that they're up to the task of getting this right, and so I would recommend a presumption that monopolists engaging in false advertising constitute monopolization. And fifth is mergers. Ton of consolidation in the industry. The FTC has responded by focusing on the divesting of overlapping products. I believe that there is a theory of unilateral effects that is well established that would cover what is going on here. And so the first thing I'd say is there should be a presumption against mergers between large companies. If you look at these large companies, they have significant advantages in insurance and reimbursement, detailing and financing, and there's no good reason for them to merge. In terms of mid-sized firms, even if I might not go up to a presumption, there are other factors to look at beyond the overlapping products. And so I look at things like must-have blockbusters, rebate walls, anti-competitive conduct. You look at the AbbVie-Allergan merger, all three of those were present in that merger. That deserved more attention. And then finally, generic mergers deserve some more attention as well. Not every generic is doing what it was supposed to do. When it starts getting a lot of its revenue from the brand side, that alters its incentives, and that should be considered. At the end of the day, the three pieces of legislation that this committee is considering would make consumers' lives better and would not touch innovation. Thank you very much.
Thank you, Professor Carey. I now recognize Professor Feldman for 5 minutes.
Mr. Chairman and esteemed members of the committee, I'm honored to be here today to address an issue that is causing real pain for patients and for those who are trying to help them. Open and vigorous competition is the backbone of US markets, but we're not seeing that in the pharmaceutical industry. We know pharma markets aren't working because we see monopoly pricing extend well beyond the statutory grant of exclusivity. That hurts patients who can't access affordable medicines, and it burdens taxpayers. Quite simply, pharmaceutical companies are repeatedly gaming the system in order to protect and extend their monopolies. Companies are doing this through schemes to block generic entry, including product hopping, pay for delay, and citizen petition abuse. Now, companies string these games out one after another to maintain monopoly pricing. This committee has an historic opportunity to address the problem. In describing this anti-competitive gaming, I would like to focus on a few key issues. First, many of the games, including product hopping, involve making some modification to an existing drug. The company then pushes the market to the new version, which is protected by shiny new patents. One can see this, for example, in the market for treating opioid use disorder, when a company switched from tablets to meltaways just before the patents expired. Now, these modification patents are often quite weak, and when generics fully challenge them in court, the generic wins 3/4 of the time. But the challenge takes years, and in the meantime, there's no competition and prices stay high. Most important, when a company makes a modification to a drug, like changing a tablet from 20 milligrams to 40 milligrams, the R&D is far less than for the drug's initial discovery. Company should be able to earn its reward in the market for the modification. It's really the massive investment in the initial discovery for which government should intervene in the market, put its thumb on the scale, and give the company years of patent protection. These gaming opportunities also mean that much of the system is focused on repurposing old drugs rather than discovering new ones. In fact, 78% of the drugs associated with new patents aren't new drugs coming on the market. They're drugs we already have. Now, against this backdrop of repeated anti-competitive gaming, the pharma industry also has become increasingly consolidated. And pharma now outsources most of its R&D, generally by buying startup after startup. All of this reduces the chances of disruption and competition in the industry. Antitrust law just hasn't kept up, either with the monopoly gaming or with the waves of mergers and buy-ups. Instead, courts and agencies tend to focus on a single behavior or a single startup purchase. That misses a lot. For example, if a dominant firm buys 100 companies, the likelihood that any one purchase harms competition is low, but the likelihood that the pattern of acquisitions harms competition is much greater. The same is true with a pattern of behavior. Much of this monopoly gaming has blossomed just in the last 15 years. It's not age old, and it's not inevitable. I am tremendously encouraged to see bipartisan efforts to address these critical needs and to help improve access to affordable prescription drugs for patients. Thank you.
Thank you, Professor Feldman. I now recognize Mr. Abbott for 5 minutes.
Thank you, Chairman Cicilline, Ranking Member Buck, distinguished members of the subcommittee. Thanks for this opportunity to testify. As Chairman Cicilline noted, I'm a former general counsel of the Federal Trade Commission. I served in other roles there as well. I also formerly served in the Antitrust Division of the Department of Justice. In my statement today, I will focus on 4 points. 1, additional funding for the federal antitrust agencies. 2, granting the FTC statutory authority over nonprofit entities. 3, what antitrust statutory changes are appropriate? 4, major legal reforms unrelated to antitrust. First, additional funding. Federal antitrust enforcement is a bipartisan endeavor, and the FTC commissioners unanimously support substantially increased funding for FTC enforcement. As already noted, in real terms, resources have diminished over the last decade for such enforcement at the FTC. I expect that the Biden administration will recommend additional funding for the Justice Department's Antitrust Division as well. Acting FTC Chairwoman Slaughter recently testified before the Senate Commerce Committee that FTC employment has remained flat despite a growing workload, with merger filings doubling in recent years. She noted that FTC resource constraints lead to difficult trade-offs that may adversely affect the pursuit of some meritorious investigations. I can attest to the accuracy of her observation based on my personal experience as FTC General Counsel. The problem of resource constraints is particularly acute in the case of healthcare merger review, given the increasing consolidation of healthcare institutions in recent years. Antitrust enforcers will need additional resources to ensure that this trend does not yield mergers and that undermine the competitive process and harm consumers. Second, FTC authority over nonprofits. Many healthcare entities, particularly hospitals, are organized as nonprofits. FTC and Antitrust Division Clayton Act merger enforcement applies both to for-profit and not-for-profit enterprises, but the FTC Act does not reach nonprofit corporations. Then FTC Chairman Simons testified in 2019 that this limitation, which makes no logical sense, has prevented the FTC from examining problematic unilateral conduct by hospitals. In short, it's high time the FTC be given statutory authority over nonprofits. Third, legislative change. While a few marginal adjustments to the antitrust statutes appear appropriate, I believe the mainstream consensus consumer welfare approach in the major statutes should be retained. I believe there's a risk that far-reaching extensive statutory changes could generate costly welfare-reducing uncertainty in antitrust enforcement. However, as noted already by a couple of speakers, targeted statutory amendments narrowly tailored to address specific competitive healthcare sector abuses may be appropriate in the right circumstances. For that reason, I testified in favor of the CREATES Act. Several distinguished scholars, including my fellow witnesses, have advanced a number of thoughtful additional targeted legislative proposals to address competitive problems affecting healthcare. I will not comment today on the merits of specific proposals, but I would respectfully suggest that before legislating, Congress seriously weigh whether the benefits of eliminating targeted harmful conduct will likely be outweighed by the costs of condemning and deterring specific instances of such conduct that could have benefited consumers. Fourth, non-antitrust issues. Major improvements to the competitive condition of the healthcare sector require far more than enhanced antitrust enforcement. Serious competitive distortions are posed by a host of state and federal statutory provisions that bedevil the healthcare sector, including, as merely one example, state certificate of need laws that restrict competitive entry. The federal antitrust agencies have, over the years, done an outstanding job in calling for statutory and legislative reforms to improve health care competition under Republican and Democratic administrations. Enhancing competition in healthcare markets, whether through enforcement or legislative and regulatory reform, has been and should remain a nonpartisan endeavor. Thank you. I look forward to your questions.
Thank you, Mr. Abbott. We will now, again, thank you to our witnesses for opening statements. We'll now proceed under the 5-minute rule for questions, and I will begin by recognizing myself for 5 minutes. Professor Feldman, in a recent op-ed, you note that between 1995 and 2015, the 60 leading pharmaceutical companies merged to only 10. As you note, this has resulted in a handful of manufacturers sourcing the vast majority of prescription drugs. And so my question is, why has there been so much consolidation in this industry? What are the effects of such extreme consolidation? And to what extent do killer acquisitions pose a problem in the pharmaceutical markets?
Thank you. The closer we can get to a free market, the better we're going to do for competition and for lowering drug prices. The competition agencies in the United States have essentially taken the view that they can manage mergers by allowing for distribution of pipeline products, for other types of changes. It simply hasn't been effective. We need both a far greater response to mergers and buy-ups of startup after startup, and we also need a second look where we look back at the mergers that have happened to see whether competition has actually improved or lessened, and then try to fix it.
Thank you, Professor Feldman. Dr. Daphne, in your written testimony, you recommend implementing a legal framework, and I quote, to explicitly prohibit healthcare mergers that enable greater exploitation of existing market power and are likely to result in harm to consumers, end quote. What are some examples of mergers in the healthcare sector that are harmful to consumers, but nonetheless go unchecked under current law? And secondly, do you think it would be helpful to shift the burden to merging parties to show that their merger would not result in higher prices or lower quality of care?
Chairman Cicilline, thank you very much for asking this question. Examples of harm that are occurring that are not currently being investigated or are not publicly or seriously so are when hospitals are buying up other hospitals, not in the exact same area, but nearby areas. So a dominant hospital in a town has a great reputation, high prices, will buy up a community hospital in a suburb and then instantly be able to roll that hospital onto its contract, raising prices, which all gets passed down to us. That's one example. Another example, hospital acquires a physician practice. Physician practice, everything's the same, puts up a sign, everything's the same for the patient, okay, which is what counts right here. Puts up a sign, says you will now be also paying hospital facility fees for this service, increases prices. These transactions are proceeding unchallenged because either the statutes don't allow or the interpretations of those statutes don't allow challenges to them on competition grounds. You second asked about shifting the burden. This is a good example where one could require the parties that are proposing such an acquisition to demonstrate why their transaction is not going to be harmful, as opposed to requiring the plaintiffs, the government, to demonstrate why it is going to be harmful to the standards that are currently required in the competition statutes.
And I take it you think that would be a good idea?
I do.
Okay, great. Professor Carolyn, my last question. You explain in your testimony that product hopping causes patients to overpay by potentially billions of dollars annually for their prescription drugs. Can you explain why this product hopping is so harmful and how the Affordable Prescriptions for Patients Act legislation, which I introduced with Ranking Member Buck and Senators Cornyn and Blumenthal, would combat this abusive practice and respond to the defense that pharmaceutical companies have expressed that preventing product hopping will somehow stifle innovation and block new treatments from coming to the market?
Sure. So product hopping is concerning because it evades the regulatory regime. Drug product substitution laws are designed to bring affordable generics to the market. When a brand company makes a tiny change just to avoid substitution, everybody suffers. The legislation would be incredibly helpful in making clear that these soft switches in which the old product is left on the market, that courts are not understanding presents a problem, is a problem. And the legislation would be incredibly helpful for that. In terms of innovation, I'd say that first, the legislation is incredibly targeted. There's a competition window that allows for challenges only in a short period of time. There are exclusions, there are justifications. Also, this is limited to the FTC under Section 5. The FTC almost never brings a case. At most, it'll be once every year or two. And then finally, in terms of innovation, this is not the first time that pharma has made this argument. I wrote an op-ed going back to 1961, in which every single time there's patent or antitrust legislation in this body, they say it's going to be the end of the world. Now there's a new variation. Oh, it's COVID. It's still the same thing. It's sort of like the boy who cried wolf.
Thank you, Professor. I now recognize the ranking member of the subcommittee, Mr. Buck, for 5 minutes.
I thank the chairman, and I would ask the chairman, I'd like to go last with my questions, but if the chairman could recognize Congressman Issa, I would very much appreciate it.
Happily, I recognize Mr. Issa for 5 minutes.
Thank you, and I want to thank the ranking member for letting me go out of order. Uh, the fact is, I support this legislation in principle. I know that as we go through the process, many companies can give us examples where they may want to have a nuance change. But let me go through a couple of quick questions that may go the other direction. We'll start with Professor Carrier. Uh, Many of the changes that we're trying to thwart with this legislation are predictable and repeatable. Uh, if we cannot get, if you will, some of these common sense reforms through, is there any reason that this body couldn't, for example, give uh, a a right of anyone not having a patent to put up barriers to, if you will, the obvious? You mentioned, or was mentioned in the earlier testimony, that, for example, uh, changing the dosage or the method of delivery, time release, each of these nuances that are currently going on at the end of a product life, uh, and the opioids are famous for them. Uh, these are in fact patentable because we allow them to be patentable, and we don't bar them based on obvious. And yet, something, if you will, medicines continue to basically add these features that are predictable and repeatable. Wouldn't you say that it's certainly within our purview to, as a matter of law, define those as obvious if we can't get some sort of middle ground with pharma and their pattern of abuse?
You're absolutely right that the patent system is incredibly important, and we need to make sure that we give the patent system the deference it deserves. At the same time, however, not every patent is valid. A lot of these patents are not on the active ingredient, and the concern with product hopping is that it is an evasion of the regulatory regime. I talked about the drug product substitution laws. The Hatch-Waxman Act put in a whole bunch of provisions to have generic competition. And so I view this as purely bipartisan legislation that is narrowly targeted, that will not affect innovation, and that will make consumers' lives better.
I want to do one more follow-up. In most areas of patent law, we all are used to the common statement that a patent, by definition, on its face, with the disclosure, has to be sufficient for someone of ordinary skill in the art to, in fact, duplicate the product. Uh, Please explain, I think, for the record, why that does not occur in biologics today, and why the entire pattern of abuse, where you're at the end of a patent life, at the point in which a biosimilar would like to produce something and doesn't have, in some cases, even the medicine, but they don't have the ability to do it because, if I'm correct, as a layperson, we have not forced the disclosure at the front end to meet that test, that if someone of ordinary skill in the art can, on the face of the disclosure, know how to duplicate the product.
You're absolutely right. And what's going on with the biologics industry is not just patent protection, not just patent thickets, but there's also trade secret protection. So even if, exactly as you mentioned, the patent system is designed to enable inventions, when a lot of the process of creating biologics is hidden under lock and key, it's hard for the biosimilar to figure that out. And so we have the patent system that's designed to serve a purpose. You don't usually have trade secrecy built on top of that. That's what's going on here, and that's an additional reason why we're not seeing enough biosimilar entry.
So let me ask it as a final question. Certainly, I appreciate trade secrets, and manufacturing nuances are abundant in the electronics industry that I came from many years ago. But in return for the bargain of providing a patent, the assumption would be that, again, someone of ordinary skill in the art, with the information that by definition someone of ordinary skill in the art has, can duplicate the product. Should we be looking at an outright recognition that the that the trade secrets cannot in fact be allowed to create a barrier if you want the patent. For example, putting it in simple terms, Coca-Cola can't have a secret formula and patent the formula. And just a quick answer, if you would, please.
Yeah, the time of the gentleman has expired, but the witness can answer briefly.
Sure. So you're absolutely right. In most areas, you have to choose between patent and trade secret. With biologics, they're compounding one on top of the other. This is absolutely worth attention.
The
Thank you,
gentleman
and thank you, Mr.
yields
Chairman,
back.
for the indulgence.
Thank you. I now recognize the gentleman from New York, Mr. Jones, for 5 minutes.
Well, thank you, Mr. Chairman, and to the ranking member for your strong leadership. This has been a pleasantly bipartisan hearing thus far, and I look forward to joining Mr. Issa in reforming our nation's patent laws. I also want to thank the esteemed witnesses on both of our panels today for joining us this afternoon. I am excited to be part of this vital effort to ensure that everyone in the United States of America can afford the prescriptions that they need. I also, of course, want to thank the sponsors of the 3 important bills before us today for their leadership. Thanks to you, we have the opportunity to help patients and families across the United States, and I'm so committed to working with you. Today, pharmaceutical companies are confronting the American people with a terrible choice: miss rent payments and skip meals to pay for their prescriptions, or go without the life-saving medications that they need. I know the toll that takes firsthand because when I was growing up, my family didn't always know if we could afford the health care that we needed. There is simply no reason, indeed no excuse, for leaving patients and their families struggling to get by just so that pharmaceutical profits can continue to soar. Professor Carrier, in your testimony today, you have illuminated a source of the crisis of high drug prices that we have not yet heard enough about, and that is the consolidated power of the biggest pharmaceutical firms. As pharmaceutical companies have expanded through mergers, they have raised drug prices higher and higher. I've been hearing that same message from a range of leading experts, from the American Economic Liberties Project to my courageous colleagues like Katie Porter and, of course, our distinguished chair, David Cicilline. To help clarify the stakes for everyone, could you share an example of a pharmaceutical merger that shows how these mergers can harm patients, families, and our communities?
Sure. So thank you for your attention on mergers, which are a really important issue. And I would focus on the AbbVie-Allergan merger, where this received a lot of attention, but really at the end of the day, the FTC solution just came down to forcing the divestiture of a few overlapping products. When you think about the harm, however, it comes from more than just particular markets. So in this case, both companies had blockbuster products in AbbVie's Humira and Allergan's Botox. And so when you get all of these must-have products in one company, they have a lot of power to demand rebates from insurance companies and PBMs, and that makes it harder for consumers who need to have these medications. At the same time, you have these rebate walls that make it tougher for any other competitor that can't compete with that broad range of products, and you have some companies that are in some antitrust hot water. And so the fact that they have been accused of pay-for-delay settlements, of, in the Allergan case, tribal immunity and citizen petition challenges, there is a lot that's going on that's not captured by the current approach. And I think that this harms consumers, and therefore a new approach should be considered.
Last month, acting FTC Chair Rebecca Kelly Slaughter declared that, quote, given the high volume of pharmaceutical mergers, skyrocketing drug prices, and ongoing concerns about anti-competitive conduct in the industry, it is imperative that the FTC rethink its approach toward pharmaceutical merger review. In your testimony, you called for imposing a presumption against mergers between large pharmaceutical companies. Can you explain your proposal further and tell us more about why a presumption against these mergers is so important to ensuring that everyone can afford the drug they need?
Absolutely. So Patricia Danzon at Wharton and I have an article forthcoming in the Antitrust Law Journal where we look at pharmaceutical mergers and we look at the key element of size. Size makes a really big difference. And basically, we conclude that there's no good reason for two large companies to merge. They have entrenched advantages in things like financing, marketing and sales, insurance and reimbursement. You put that all together, it makes it almost impossible for anyone else to compete. Plus, there's no good innovation reason for two large firms to merge. So that's why we suggest a presumption against the merger of two large firms. With mid-sized firms, I take a lot of those factors, might not go all the way to presumption, but I still would apply those factors. And so the size of the firm really needs to be considered.
Thank you so much. Professor Daphne, let me ask you as well, how would it help patients if we made certain kinds of healthcare mergers presumptively unlawful?
Thank you for the question. If we took a set of healthcare mergers that are known typically to be damaging to consumers and insisted that the acquiring parties demonstrate that they are not going to damage consumers, that would save substantial regulatory resources.
Thank you so much. Thank you, Mr. Chairman. I yield back.
The gentleman yields back. I now recognize the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and thanks to all my colleagues. It is rare, as has been noted, for us to have bipartisan things to work on these days in judiciary. So this is a refreshing hearing that we've had so far.
Mr. Johnson, I won't
And
take
just had
this
a couple
time away
questions.
from you, but not rare on the Antitrust Subcommittee.
Oh, yes, and I salute you for that, sir. That's you and Ken Buck as well. Listen, this is a big problem, a big issue, and there's a lot to deal with, and so it's not even really fair to give these witnesses just 5 minutes apiece. I'm glad to have some questions. Let me drill down into something that is of great concern to a lot of people, and that is the certificates of need issue. Let me ask Mr. Abbott, if you will, maybe describe what that is, and then talk a little bit about the anti-competitive effects of certificates of need.
Thank you for that question, Congress. I mean, certificate of need basically is a state law provision which states that any additional investment, say in a hospital, healthcare facility, depending upon how it's defined, must be justified. Often you will have a panel that will decide if a particular investment is justified and is cost effective. And the theory, if you find out about it, about certificates of need, is that concern about scarce resources, overinvestment in certain resources, it's cost saving in short. But the reality is, and the FTC and the Justice Department over the last 20 years have done many studies of certificates of need. They've shown that in reality, certificates of need cause barriers to entry. It is a way, for example, that a powerful incumbent hospital might argue that, oh, well, you don't really need new beds, you don't really need new entry because our supply of hospital facilities is sufficient. That can prevent badly needed entry. It also, the existing certificate of need law prevented the FTC from doing anything about a merger to monopoly in the state of Georgia in the Phoebe Putney case. Won the case before the Supreme Court, but the relief, the sort of asset change in hands of assets required in order to get relief, get certain divestitures, was effectively blocked by a certificate of need law in the state of Georgia. And this has been totally bipartisan. Both Republican and Democratic administrations, the FTC and Justice Department, have regularly submitted letters saying we have found certificates of need to be anti-competitive. We recommend against them. They don't really do much to save resources at all. Their main effect really is to limit competition, which, as we've already heard, can raise prices and reduce quality.
Very good. So if we would at least need, they weren't required for a particular service, just in layman's terms, how would that improve the healthcare experience for the average consumer over time? I mean, the presumption is it would unleash more competition, right? I mean, is that oversimplifying it?
Yes, Congressman, and indeed it would. It would allow a new entry in markets. It would allow the market to decide how many beds are needed, what new facilities can be brought forth, say an imaging facility. And it would prevent particularly rural or regional monopolies from entrenching their market power. As I mentioned, that was a problem in Georgia, so I think that's a particular issue. And I don't have the specific numbers in front of me, be glad to provide them to you, but as I say, I think there's been a lot of research And the research that I'm aware of unequivocally has shown that this tends to be anti-competitive and drive up prices.
I appreciate that. And if it would not be too much effort, if you could supply that to us after the hearing, that'd be helpful because we need real ammunition and evidence for making these changes, and that'd be a big help. So my technical glitches, Mr. Chairman, so I yield back. Thank you.
The gentleman yields back. Mr. Raskin, if you turn on your camera, you are next. If not, we'll move to Ms. Jayapal.
Yes.
Oh.
Thank you, Mr. Chairman. I didn't realize I was coming up. Thank you so much. You know, a number of our colleagues have remarked upon the pleasant bipartisanship of this hearing. And I wonder if we'd take a moment to reflect on what that means historically. I know that that socialism has become part of the political dialogue in America today. But I wonder if we could examine the way in which antitrust enforcement really became an answer to socialists who were saying that we needed to take over the big businesses because they were so out of control. But the progressive response, progressives meaning both Republicans like Teddy Roosevelt and Democrats like Franklin D. Roosevelt, was to say, let's break up the big businesses to make sure that there's real competition. And I'm wondering, you know, Professor Feldman, perhaps if you would reflect for a moment on the development of antitrust law as a response to other efforts to deal with the problem of monopoly power in the country. I think you're muted.
Thank you. Markets need to be fair, open, and efficient if we are going to have the type of free market economy that you envision there. The antitrust laws are an essential partner for making sure that we can do that. Unfortunately, antitrust laws haven't kept up with the sophistication that has happened in the healthcare field across the way and with the games that have developed. If we want antitrust to be an effective tool and to guarantee the free market that we all would like, we're going to have to update it.
And on that point, it does seem as if within the antitrust field, we're always playing catch up with the various the innovations by businesses or would-be monopolists to take advantage of their power. And I suppose that's built into the system too. Is there any way that we can create an antitrust system that is more readily and nimbly responsive to the kinds of things that people have been talking about today, the kinds of schemes that are derived to take advantage of market power?
It's always more difficult for government to stay ahead, particularly for a body like Congress that is deliberative. I believe one has to pass legislation that has two parts. One is examples of specific targeted behaviors that are inappropriate, and another is sufficient language that gives the agencies the space they need to respond as new games develop.
Okay, thank you. And Professor Daphne, let me ask you this question. What have we learned from many decades of antitrust legal enforcement as to what the most effective ways are to make government more rapidly and readily enabled to deal with the kinds of schemes that you're talking about?
Thank you for the question, Representative Raskin. So to just elaborate on the previous query, there needs to be an incentive not to play games. When those incentives to play games exist, when incentives to merge for the purpose of raising price because we are willing to pay whatever price is charged or the increase in price, when those incentives exist, that's when people play games, that's when mergers happen. How do you prevent them? Research shows that a lot of mergers that have been able to go through under the current enforcement regime have caused substantial price increases. So if we strengthen enforcers' hands by increasing the reportability of transactions, because there's evidence that they are not typically challenged below the thresholds, if we reduce the burden of proof in certain transactions, and if we explicitly make unlawful certain practices that are gaming, I think we'll end up with better outcome.
All right. So, Mr. Chairman, I just want the record to demonstrate that both parties here, I think, are looking for effective public action to guarantee real market competition. No party, either Republican or Democrat, seems to be looking for a government takeover of the healthcare sector or any other business sector. And this is very much within the tradition and mainstream of American progressive legal and policy action. I yield back to you.
The gentleman yields back. I now recognize the gentleman from Florida, Mr. Stubbe, for 5 minutes.
Thank you, Mr. Chairman. My questions are for Mr. Abbott. Beyond certificate of needs, Mr. Johnson asked you about that. Can you further discuss state policies that might be labeled as, quote, anti-competitive? Or are these purely state issues, or is there a role for Congress to play?
Well, thanks for that question, Congressman. Certainly, there are occupational licensing restrictions that unnecessarily restrict competition, certainly in healthcare. A good example is restrictions on nurse practitioner practice. We see that there are many boards, health-related boards in states that have limited competition without any good justification. For example, in the North Carolina Dental Board case, which is FTC won before the Supreme Court, this was a case where you had a dental regulatory board dominated by dentists that in fact would pass the regulation effectively preventing clinics that providing whitening services without the involvement of a dentist. Obviously drove prices up. South Carolina, there were dental board restrictions, again, examined by the FTC, that prevented services being offered by dental hygienists to poor people in rural areas without the presence of a dentist. That tended to raise costs and also limit valuable dental services. In general, occupational licensing is a big problem. I think this, again, bipartisan. The Obama administration recommended major occupational licensing legal reforms in summer of 2016. And it certainly might be, I know Senator Lee, I think, supported legislation that would allow people in the armed forces, if you had a spouse, who would not need to get licensing elsewhere. Given the interstate nature of movement of many American professionals, there's an argument you could have nationwide licensing of physicians, or at least lowering of barriers for state that unnecessarily delay new licensing of physicians in particular states. I won't get, it's a rather complicated topic, but the certificate of public advantage by which the state may give an antitrust immunity for businesses that want to merge or consolidate, that also may have helped consolidations. And the argument there was that this was to promote better outcomes and efficiencies. But again, I think some economists say there's little evidence of that. So in short, there are a number of restrictions, state restrictions, some of which could be preempted if Congress wanted to do that.
It's my understanding that the Trump administration, HHS, issued a final rule on Medicare Part F. Can you talk about the current status of that rule and whether it would help with the issues that we're discussing today, in particular, realigning incentives in healthcare?
I apologize, Congressman. I'm really not an expert on details of that rule. I'm glad to get back to you and provide a response for the record.
That's fine. I can move on to my next question. You address Obamacare or the Affordable Care Act in your testimony and note that it accelerated the consolidation of hospitals, health systems, and medical groups. Could you explain on why this has been detrimental, particularly to consumers and patients?
Right. Well, there's certainly some research by a number of economists that suggests that the incentives it did create incentives for consolidation, and that those incentives tended to increase concentration indeed, and also the set of reimbursement rules. Again, I'm not a full expert on that. I just know I've seen literature suggesting that that was the case. Again, I'm glad to provide more details. It's a complicated topic. I'm more of a pure antitrust person, but I've certainly seen that literature from a number of economists whom I view as reputable.
Well, let me take it a little broader. What are the dangers of broad, sweeping antitrust laws to address very narrow healthcare issues? How can the problems discussed today be addressed in an appropriately narrow way?
Well, I think the danger with broad laws, such as, for instance, generally reversing presumptions in mergers or presumptions against mergers of firms of a certain size, or changing the language of Section 2 of the Sherman Act, some of the proposals out there, apply to all industries and make healthcare is unusual precisely because you have a combination of extensive state and federal regulation, a lot of payments going, as you see, through Medicare and Medicaid, so involving government involvement. You've got state licensing restrictions. You've got federal FDA restrictions, HHS restrictions. This combination of, you had a Hatch-Waxman Act, which created incentives for gaming. This combination of laws enacted even with the best of intentions created opportunities for regulations and laws to strategically be used to harm entry or deny competition. It was an example.
The time of the gentleman has expired, so I just asked the witness to wrap up your answer, please.
Yeah, yes, sir. Yes, Mr. Chairman. So that basically is it.
I thank the gentleman. The gentleman yields back. I now recognize the distinguished gentleman from New York and the author of the Stop Stalling Access to Affordable Medications Act, Mr. Jeffries, for 5 minutes.
Thank the distinguished chair for your great leadership. I also thank Ranking Member Buck for his leadership, particularly as it relates to this issue of citizen petition abuse. Professor Carrier, the FDA has a citizen petition process that was meant to provide for an opportunity to raise legitimate concerns about the health and safety of a new prescription drug or device that's under review by the agency. Is that right?
That's correct.
And this process does seem to make sense in theory, consistent with its intent. But is there reason to believe that it has been increasingly abused in an anti-competitive manner by brand name drug companies as part of an effort to delay the entry of generics onto the market?
Absolutely. So I've conducted 2 empirical studies of all citizen petitions filed between 2001 and 2015, and my most recent one found that of the 505Q petitions, which are petitions against a pending generic, the FDA denied 92% of these petitions. That figure rose to 98%, 49 out of 50, when they were filed at the last minute. So this certainly is an abuse.
So the overwhelming majority of petitions filed actually are found to be frivolous, or at least lacking merit. Is that correct?
Exactly, yes.
Now, this would be one thing if this were citizens actually using a legitimate process that were put into place. But could you tell us what your study has found in terms of who actually is filing these petitions?
The brand firms are the ones that are filing these petitions. 92% of these 505Q petitions were filed by brand firms, and there are basically almost none that are filed by individual citizens.
So the brand firms are actually filing these petitions. They're subsequently found to be almost always meritorious, and that results in the delay of lower cost generic drugs being brought to the market. Is that right?
Absolutely, because as frivolous as a citizen petition is, the FDA has never summarily denied one on its face. It has that power, but it has never used it because it has to go through what are these long petitions, lots of scientific language, can't do it immediately, and so that delays generic entry.
So how does this stalling tactic adversely impact the consumer?
Every day that a consumer does not have access to an affordable generic medicine is a bad day for that consumer. Citizen petitions are used along with other conduct, like product hopping and pay-for-delay settlements, all making it harder for consumers to afford the medications that they need.
So generic drugs generally cost 80 to 85% less than the brand name drugs on average, is that right?
Yes.
And so this would be part of the reason why adversely delaying the arrival of generic drugs onto the market clearly has a significant financial impact on the consumer.
Absolutely. Every day of delayed generic entry harms the consumer.
Now, is there any explanation that has been offered by the brand name companies as to the justification to engage in this type of frivolous practice?
Well, they claim that they are raising safety concerns, but when courts look at this, sometimes it's a sham. Sometimes there's no good reason for what they're doing. Oftentimes, the brand companies hide behind the First Amendment and petitioning immunity, but at the end of the day, when they're asking the generic to do something that it doesn't do itself, or they knew about something and waited years to raise it, that sheds some real questions on what they're doing.
Well, thank you for your work. Thank you for your testimony. In the past, this committee has unanimously moved forward legislation to address this egregious practice with the support of the chairman of the subcommittee as well as the chairman of the full committee. We've reintroduced legislation to address this. It is being championed on the other side of the aisle by Ranking Member Buck, and we look forward to addressing this egregious practice. Again, thank you for your testimony.
Thank you.
The gentleman yields back. I now recognize the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Mr. Chairman. And I, too, am glad for the bipartisan approach here and the uniform commitment to improving competition in the healthcare market. I think that when I was a state legislator for 5 years, I was consistently pro-CON repeal. I favor, I think the 3 bills that have been discussed today are no-brainers. But I want to take up something that Mr. Stubbe mentioned. I thought this as I was sort of preparing for this hearing, then saw some materials that suggested there's something to it. In 2014, Scott Gottlieb talked about a flurry of takeover transactions in the healthcare space set in motion by the Affordable Care Act. Wall Street Journal described in next year, 2015, 5 years after the Affordable Care Act helped set off a healthcare merger frenzy, the pace of consolidation is accelerating. I even understand, looking at some other material here, that the architects of the Affordable Care Act were convinced that consolidation in healthcare would lead to decreased healthcare spending by eliminating duplication, standardizing treatment protocols, and incentivizing better utilization. So that is to say, not only did the law encourage consolidation throughout the healthcare space as a matter of result, it was intended to do so on the theory that would result in lower costs and price. And so maybe Professor Feldman, I certainly have liked what you've had to say about markets. And I wonder, is that true of the ACA? And if it is, are we not engaged in sort of a Sisyphean or futile task to try to advance competition in the healthcare space if the primary design of the healthcare system through ACA is designed to discourage, and promote consolidation?
Professor, I believe you might be on mute.
My apologies, I'm having a little equipment problems here. So I have sometimes been asked whether it might be better to just give up on competition in the healthcare space, whether you're talking about hospitals or pharmaceuticals, because it's too difficult, it's too complicated, it's already layered with too many regulations. Personally, I don't believe that. I believe that even if it is not perfect, the closer we can get to competition, the more we can make the changes that will encourage that, the better off our patients will be. So I understand there are pressures throughout the system, but I think we have extraordinary opportunities to try to act in the patient's interests.
Do you have a view as to whether the ACA does promote consolidation or not?
It's an interesting question, sir. I would love to take the time to think about that and come back
Okay.
to you with a thoughtful
Let
response.
me go to Dr. Daphne then and see whether you have a view of that question, Dr. Daphne.
Certainly. Well, it's been 10 years since the ACA was passed. We've seen enormous consolidation during that period. There's no evidence that it's causal, right? So we don't have a counterfactual state of the world, what would have happened. And there was a lot of activity before. What I will say is that the act promoted coordination of multiple providers and that some people have invoked it as a reason for a merger. If I'm going to be responsible for the whole episode of care, then I ought to own all the components of the delivery system. The problem is that a lot of those transactions have not been about the whole episode of care. That is, the physician, the hospital, the rehab clinic, home health. It's been a lot about buying up the same of what you do and more horizontal consolidation.
Is it possible, Dr. Daphne, that if you promote consolidation, let's say among the healthcare plans, and then you are robustly enforcing antitrust law as against hospital systems or pharmaceutical companies, that you might produce distortions that would be problematic?
I believe you just asked, would it be problematic to consolidate the health insurers while keeping the provider sector competitive? My answer would be yes, that would concern me. There is evidence that when insurers are larger, they tend to negotiate lower prices, but there's no evidence they pass those on down to consumers. Think about it. What's the incentive? If you don't have very many rivals as an insurer, why would you pass on savings?
Yeah. I'm inclined to yield, if I had any time left, to the gentleman from Maryland to address this, because he might be more even on the point. But I find that to be a fascinating issue that we are, because I believe in competition in the healthcare space, glad we're interested in it on a bipartisan basis, confused if ACA was designed in part to impair it. But I'll yield back because my time's out.
The gentleman yields back. I now recognize the gentlelady from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, for a very important hearing. I think we all understand that when proponents of consolidation in healthcare promised us better quality of care, the reality that we got is that patients have been forced to pay exorbitantly high medical costs in exchange for worse care. And we see a system that's plagued with unregulated mergers, hospital closures, skyrocketing healthcare costs, only exacerbated by COVID-19. At a time in which healthcare services are needed the most, medical institutions serving low-income communities, communities of color, rural communities have fared worse than wealthier institutions, despite serving patients who have suffered a disproportionate rate of COVID-19 infections and deaths. And so I think the issue of consolidation is actually deeply tied to the issues of health inequity for so many communities. Dr. Daphne, in your article, Healthcare Needs Real Competition, you mentioned that, quote, the US healthcare system is inefficient, unreliable, and crushingly expensive. Has a lack of fair competition contributed to these issues, and if so, how?
Thank you for the question, Representative Jayapal. Absolutely. Unequivocally, the source of our higher spending is not the health of our population, not that we use more services, but that we pay higher prices for them. Now, there's some difference in the intensity of the service and the technology, but you could debate a little bit the level. But the growth in prices, the explosion in commercial prices that has coincided with what Representative Bishop was observing, the increase in consolidation in the healthcare sector, right? That's unmistakable. And then layer on academic research that looks really at, what happens when there is a discrete change in consolidation. And there's significant evidence across a range of sectors, both providers and insurers, that increasing the market power enables higher prices and is a driver.
And just for people who are listening, how does hospital consolidation affect their quality of care, patient choice, patient experience, even, what effects does it have on small businesses?
Right. A couple of ways. First of all, it affects spending, right? So it's going to pass through higher out-of-pocket spending when you have your, increases your deductibles, burdens the employers because they have higher premiums. Second of all, a reduction in your options, a reduction there's evidence of a reduction in patient experience and no evidence of improvements in clinical outcomes or other process measures.
And in your testimony, you also noted the role of nonprofit hospitals. Nonprofit hospitals are often considered charitable institutions. In 2019, 66% of all hospital and health system mergers and acquisitions involved nonprofit entities. In the upcoming documentary Inhospitable, directed by Sandra Alvarez, the fact that nonprofit hospitals behave like for-profit hospitals is discussed. Can you talk a little bit about how nonprofit and for-profit hospitals engage in similar behaviors to maximize profits? If you think that's true, or if you don't, explain why that's not the case.
Not-for-profits and for-profits in healthcare are in the same industry. And even if not-for-profits are not seeking to return those profits to shareholders, they need to break even. And they also have other sources where they put those profits, sometimes salaries, but often there's the programs that they deem to be valuable, which might not be what your taxpayer wants to pay for. Certainly, the research has not found that not-for-profits are increasing prices less after mergers. So I would put that out there. What we should not have is a difference in terms of enforcement vis-a-vis the not-for-profits, and the fact that the FTC is not permitted to challenge anti-competitive conduct by not-for-profits is nonsensical.
Sorry, did you get cut off or what?
No, I'm brief.
Oh, okay, it was nonsense. Okay, great. So I guess you're getting at this. I wanted to ask you if these large consolidated nonprofit systems do require antitrust scrutiny due to their tax exempt status. Can you say a little bit more about that?
Well, two items. One is they absolutely require antitrust scrutiny, and the authorities have brought a number of cases, challenges, and have succeeded in many of them. The second is that there are other statutes that state attorneys general can enforce to try to ensure the not-for-profits are fulfilling the community benefit standards.
So very quickly, just on private equity firms, because my time is out, how can antitrust laws and regulations be strengthened for better oversight to prevent harmful non-horizontal mergers in healthcare?
More reporting and when appropriate, shifting of burden, have the parties demonstrate why the transaction is not harmful.
Thank you so much, Dr. Daphne. I yield back, Mr. Chairman.
The gentlewoman yields back. I now recognize the gentlewoman from Minnesota, Ms. Fischbach, for 5 minutes.
There we go. I got it unmuted. Thank you so much, Mr. Chair. And I just wanted to ask a little bit about to Mr. Abbott about the federal role in state restrictions. I know that Congressman Stubbe asked a little bit about the certificates of need, but maybe he could talk a little bit more about the federal role, in the state restrictions as related to the healthcare competition.
Well, thank you very much, Congresswoman, for that question. Federal role, I think part of it is competition advocacy, but not always successful. As I think I indicated, the FTC and Justice Department have advocated a repeal of con laws because just on a bipartisan basis. Now, to the extent that con laws are viewed as having a harmful effect on interstate commerce in principle, and because they harm the competitive process, you could have an argument for federal preemption if the federal government wanted to do that. Similarly with COPA laws. Federal government has chosen not to do that, but certainly in part of the problem, and of course these laws have some defenders, is that they were in a way special interest. Incumbents can take advantage of them to forestall competition. Occupational licensing should be a no-brainer in my view, but it's not. There's been some litigation against state occupational licensing restrictions on constitutional grounds by the Institute of Justice, for example. But there's no really good reason that I'm aware of why artificial restrictions on nurse practitioners, on other medical providers, limitations on not science or based on activities, as I say, of dental hygienists should be maintained. Again, this gets sensitive because it goes to the nature of state licensing, which is historically a state function. So I think the federal government certainly should look at those sets of conditions, and particularly how state regulation interacts with federal law and undermines the concern about consolidation. Certainly that may have some effect on consolidation as well, because it denies con laws, for example, may have precluded new entry.
Thank you. And I will just say, I know that a couple of people have mentioned that consolidation, and I guess it hasn't been mentioned, I don't think, that regarding the fact I represent a rural district, and so consolidation really does affect those rural districts and rural healthcare in general. But Mr. Abbott, maybe just briefly, I only have another minute or so, but maybe you could talk a little bit about how the regulation compliance cost and all of the regulatory costs that those healthcare providers experience, whether it's hospitals, pharmaceuticals, but how do those create barriers to entry and make competition harder?
Right. Well, competition, you're asking in addition to the restrictions I already mentioned, additional restrictions?
Yeah, yep. What kind of that regulation and we just have, I wanted to keep it short because I only have a minute or so, but just if there was anything on that regulation, those regulatory issues.
Right. I think major reforms for occupational licensing I've already mentioned. When I was asked earlier, Congresswoman, about this is on state regulation, it's federal regulation about Obamacare, one article I would mention by Christopher Pope of the Heritage Foundation, and I'll describe some of the ways in which accountable care organizations and tended to promote, like it or not, consolidation by dispersing capitated payments for integrated organizations to provide all-inclusive packages to Medicare and employees, and encouraging vertical integration, also some horizontal integration. I'll be glad to provide additional information on how federal and state regulations may have diminished competition. It's a very complicated topic. Lots of my colleagues at the Mercatus Foundation, Mercatus Center, have written about that.
The time of the gentleman has expired. The gentlewoman yields back. Now recognize the distinguished gentleman from the state of Florida, Mr. Deutsch, for 5 minutes.
Thank you, Chairman Cicilline. Thank you for your leadership of this subcommittee, and thank you for using that leadership to focus on affordable health care for the American people. It's clear to me that sticker shock Americans are seeing when they fill a prescription or discharge from the hospital isn't the product of supply and demand. Healthcare markets are broken, and in the prescription drug market, gaming and abusing the patent system robs us of innovative new therapies. We have a responsibility to stop this profiteering that is leaving too many Americans either broke or sick or both. This is urgent, and I acknowledge that for me and Mr. Chairman, for you and for so many of us on this subcommittee, we agree completely with the president when he said last night that we should give Medicare the power to negotiate directly on behalf of beneficiaries to get fair drug prices. But this hearing is focused on the things that all of us, I believe, agree on, things that the Judiciary Committee approved last Congress. So we need to keep up the momentum to get these bills done this year. And with that, Professor Carrier, I wanted to ask you, amid the COVID-19 health emergency, the opioid overdose epidemic is surging. And according to provisional data from the CDC, Over 81,000 drug overdose deaths occurred in the United States in the 12 months ending in May 2020, the highest number of overdose deaths ever recorded in a 12-month period. And one of the best tools to help people find recovery and save their lives is medication-assisted treatment. Now, you mentioned that one of the drugs used to treat opioid use disorders is Suboxone. Can you explain the story of what the drug company did when the patent was about to expire?
Absolutely. So thank you for the question. Suboxone is a poster child for all of this anti-competitive conduct being used together. So first we begin with product hopping. Initially, the medicine could be taken in tablet form. Then the company said, you know what, we're going to switch it to a film form. And when it did that, even though the patients preferred the tablets because they were easier to take, the film was irritating, it could blow in the wind, children would ingest it, so it was actually less safe. Nonetheless, what the manufacturer, Reckitt, said was that the tablet was the one that wasn't safe. So the film is the thing that the kids are putting in their mouths, but Reckitt is saying the tablet is not safe. And so it switches the market, it gives up all those sales from the tablet that everybody likes, and then it goes to stage two. So stage two is then the citizen petition. And so it files a petition with the FDA, and it says, withdraw the tablets. Now, these are the tablets that it had been selling for years, and it had never said there was a safety problem. And so the court said, this is a joke. This is objectively baseless because you dismissed this safety concern less than 1 month before when you told the FDA that the product was, quote, successful and needed no further changes. And it was so bad that the FDA referred this to the FTC for an antitrust investigation. And so there you have a product hop together with a citizen petition, basically disparaging your own product that you've been selling for years. And then together with that, you had the REMS program. Again, the CREATES Act is designed to deal with the REMS program. It's gotten a whole lot better. But in that one example, and again, this is real harm and people are really suffering, you have a drug company putting together at least 3 significant types of anti-competitive conduct.
And can you just tell us what was the annual sales for Suboxone?
I do not know off the top of my head the annual sales.
My understanding is it's close to $700 million. And when you say that it makes no sense when pharmaceutical companies use these product hopping strategies, what does that mean? Help us understand that.
So in antitrust law, there is a very, very conservative test called the no economic sense test, which says, defendant, monopolist, if you have any reason at all for doing what you're doing other than harming a rival, then it's fine. So it's more deferential than the rule of reason. Under the rule of reason, courts balance anti-competitive against pro-competitive effects. The no economic sense test is as conservative as you could get. Nonetheless, this conduct, and by the way, again, most reformulations are fine. 80% take place outside what's called the generic window when we expect generic competition to happen. So we're just talking about a really small handful, but those small handful are completely anti-competitive. They undercut the regulatory regime, and there's no excuse at all for it. So when I say there's no economic sense, there's literally no reason that Suboxone would badmouth its own product, would sell tablets for years, and then say, oh, FDA, take this off the market because it's unsafe. That makes no sense at all other than harming generic competition.
And that's why we're here today, Mr. Chairman. Thanks so much for calling this hearing, and I thank the witnesses.
The gentleman yields back. I now recognize the gentlewoman from Indiana, Ms. Bartz, for 5 minutes.
Thank you, Mr. Chairman, member of the committee. I appreciate this discussion. Actually, as someone who worked on major healthcare reform in the state of Indiana and also work in Fortune 500 world, I can tell you we have a huge monopoly problem in the healthcare market. Enormous amount of horizontal vertical integration, dominance of health systems, aggressive vertical merger, hostile takeovers, ton of anti-competitive clauses, steering, all or nothing, gag clauses, steering. It's really problematic. And it's really in the whole healthcare, we talk about prescription drugs, it's only 10% of healthcare spending. Over half of healthcare is hospital and professional services. And we have to have that discussion too. But if you look at that when it started, it's actually started after World War II due to government interventions. When we started doing wage and price controls, then we continue doing them more and more until Affordable Care Act did actually very conscious effort to consolidate more, and it really took it to the next level. And then so we created, as Friedman said, political entrepreneurship due to partially socialized medical care, where now this politicians compete for votes by offering government services. Special interest groups are fighting with each other in political arena. It was protectionist, and they want to shield themselves from market competition and kind of, shift the cost like hot potato. So this consolidation and government interventions led to rise of oligopolies in every market, but healthcare market is really bad. So we're looking at some of these bills, and I think these are good initiatives, but they're really a top-down, not bottom-up approach. We're not looking at the causes, but treating symptoms and consequences of bad policies. If you look at Shams citizen petition, why we're not talking by FDA? If we're looking, sue and settle, our agency have friendly settlement lawsuits they're doing too with some of the stakeholders, and actually Senator Grassley and I'm working on some bill. We just filed the bill, hopefully this committee can support it. If we look at a product hope, and why don't we look at patent law? Our American Invents Act, created a lot of advantages for larger stakeholders in our intellectual property laws. So my question is, and I'll maybe ask Mr. Abbott, are there any approaches that we can do and the bottom up that actually will be way more effective, that constantly just kind of picking losers and winners and have more government interventions where we'll see how it's going to be effective? And I'm supportive to do something. I'm actually not against this bill, but I think it's a piecemeal approach and it's not going to help. So do you have any other ideas, Mr. Abbott, what we can do?
Well, thank you, Congresswoman, for that question. I certainly, as I say, may seem simplistic, but I think that regulatory reform and competition advocacy are very, very important, including on issues affecting potential reform to the ACA. Now, there were efforts, I know, from the Federal Trade Commission in the last administration to work with HHS to see what they could, within the regulatory system, do to, and I was not intimately involved at all, but some of my colleagues and the FTC were involved in policy office, working with HHS to try and see if they could reduce the regulatory costs and the incentives, really, as you suggested, to potential consolidation. I think, again, if we view this as a bipartisan matter, there are a lot of regulatory improvements that could be had, and I would certainly think that the FTC has 70 PhD economists. Many of them have spent a lot of time thinking about the healthcare system. I would hope that they could perhaps be given a greater role in policy advocacy, working with the executive branch, and also openly filing advocacy letters with the states. Obviously, it's a new administration will have to decide how it wants to allocate its resources. But I think that is perfectly consistent with the policy also of trying to be very aggressive in going after anti-competitive transactions, which acting chairwoman Slaughter has said. I think they could go hand in hand.
I think I yield back.
The gentlewoman yields back. I now recognize the gentlewoman from Pennsylvania, Ms. Dean, for 5 minutes.
Thank you, Mr. Chairman. And man, oh man, I am impressed with these two panels. Thank you for assembling all these terrific testifiers, senators, members of the House, and all these experts. I want to follow up on something that many have touched on, but most recently Representative Deutsch. Professor Feldman, I'm looking at, and I'm going to study more closely, your article entitled "May Your Drug Price Be Evergreen," published in the Journal of Law and Biosciences. It was in December of 2018. I want to examine the problem of orphan drug pricing and the protection of the Orphan Drug Act and how it has been really misapplied to the detriment of the marketplace, to the detriment of patients very often. I've introduced legislation, the Fairness in Orphan Drug Exclusivity Act, which would carefully and narrowly close a current loophole in the Orphan Drug Act. The second criteria of the Orphan Drug Act allows a manufacturer to qualify for orphan drug designation if there are more than 200,000 patients affected, but if the manufacturer has no reasonable expectation to recoup costs. Unfortunately, a company approved under this criteria, as we have seen and you have talked about, can grandfather themselves into an orphan drug designation if a newly approved product has the same active ingredient, regardless if the company now has the ability to recoup costs. I was looking at just even the beginning of your article in which you analyzed more than 60,000 drug data points from 2005 to 2015, and you said that the results show a startling departure from the classical conceptualization of intellectual property protection for pharmaceuticals. Rather than creating new medicines, pharmaceutical companies are largely recycling and repurposing old ones. Specifically, 78% of the drugs associated with new patents were not new drugs. Would you just comment on this use, this narrow use of orphan drug exclusivity, what it's doing to the marketplace, and would a closing of that loophole, the misuse of the very act that is supposed to bring drugs to market for patients who otherwise have either rare disease or the company has no ability to recoup costs, is now been misused, protecting companies to make billions of dollars?
Thank you for the question. The Orphan Drug Act was intended for when companies could not possibly recoup their costs, but instead we're seeing big dollar returns. So for example, in 2015, out of the 10 drugs with the highest annual sales revenue, 7 were orphan drugs. To paraphrase an old opera, today everyone claims to be an orphan. The loophole, closing that loophole that you talked about would go a long way for helping people who are suffering from opioid use disorder and also other patients who are struggling to reach affordable medications.
Well, I really appreciate that. And the area of opioid overdose and death is one that is near and dear to my heart. And as Representative Deutsch pointed out, in this pandemic, the number of deaths from opioid overdose is dramatically up. It is possible that that number in the 12 months of the pandemic will reach 100,000 people in this country dead. And so we need manufacturers and pharmaceutical companies who want to be a part of the solution, not a part of just the profits. If you would broaden it out, what is this lack of competition, this protection of marketplace and lack of competition do more broadly?
The problem is access to affordable medications for our patients. When we allow drug companies to extend their monopoly pricing long past the time of the patent grant and the original patent grant to pile on protections one after another, we prevent patients from getting access to that medication. That's extraordinarily important for healthcare in this country.
Something you talked about was slicing up. I think you called it the salami slicing.
Salami slicing.
Thank you. Can you describe that phenomena and how that's getting in the way of access to medication at affordable prices?
Now, the Orphan Drug Act is intended to apply to drugs that reach only small populations. So companies slice and dice up their populations and then apply for serial orphan drug designations. We have to differentiate between marketing and innovation. So here, companies haven't created something new. They've just figured out how to adapt it to a new market, how to sell it differently. We don't give patents for marketing.
Well, I really appreciate your work and the work of all of the esteemed testifiers. And I also want to compliment the entire subcommittee. It is a bright moment of bipartisanship where we're recognizing Democrats, Republicans, that this is an issue that's really important. That's why I have enjoyed Republican support on my bill, a bill that would close the loophole by requiring a company, when applying for the new product, to demonstrate their ability or inability to recoup development costs, preserving the incentives to develop products to treat rare diseases. We don't want to have any impact on the ability to incentivize R&D around rare diseases, but we do need to close the loophole. And with that, Mr. Chairman, I thank you and I yield back.
And it is why we welcomed with open arms your wonderful addition to our subcommittee. Thank you for those kind words. I now recognize the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair. Senator Cornyn in the first hearing kind of alluded to this. I just wanted to underscore it once again, which is the amazing speed that we've seen from the pharmaceutical companies when it comes to COVID and the development of the vaccines. I worried sometimes we kind of lose sight of that, but I do support the bill, and I think it is something that's overdue. I just want to proceed with caution, I guess, and make sure that we do this right. The first thing I would say for Mr. Abbott is, what we did experience, many different facets of life change during COVID, and one of them was that occupational licensing laws were waived as a result of COVID. And what I'm wondering is, if there's any examples out there of laws that policymakers that we should look at before we reinstate them, because it might be an opportunity. Maybe it's not. It might be an opportunity to kind of revisit some of these licensing laws and make some changes there, both at the federal and state level.
Thank you, Congressman. I certainly, I think you're right about licensing laws. I think obviously there's certain minimum safety standards that are required in medicine, but there are many, many licensing laws that prevented, as I say, interstate movement. For example, why couldn't there be some sort of interstate compact, or better yet, some sort of national standard for medical licensing? And that could allow for easier entry and movement and easier service of rural clinics. There's the issue about, that was raised about rural hospitals. Certainly it's closure is a problem there. The antitrust agencies do recognize that small hospitals can generally emerge free from antitrust scrutiny, except in most extraordinary cases. But that doesn't deal with the problem of closures and some loss of revenues due to the COVID crisis. I mentioned already certificate of needs laws. I think some leading economists have suggested that any subsidies through ACA should probably, if it could be redirected more towards patients, not providers. Better allow patients to shop around, and in fact, nationwide provision of insurance, looking at state commissions that unnecessarily limit insurance policies. That has been called for as sort of sensible reform, given the interstate nature of that, among other things.
Very good. Just one quick question for Dr. Feldman as well. Over the last couple of weeks, I've met with a number of grocery stores in my district. Some are single store operators, and then there's some that are local chains, I would say state chains of grocery stores. Didn't meet with kind of the big box ones that we're familiar with. But in that environment, what they were all trying to relay to me was that there were supply chains that changed and were kind of segregated out as a result of COVID. And it shined a white hot spotlight on their industry, and was fascinating kind of getting their feedback. And they were worried that some of the antitrust in that area is just, was created in the 30s. It's outlived its usefulness. But I'm wondering, in the discussion we had here today, I mean, you can go too far too. And I'm just wondering if you had any comment on that.
Thank you, sir. It is important that antitrust keep pace with changes over time in many different ways. And I was struck both in that question and also with your earlier comment about the COVID-19 vaccines and keeping all of the experiences that we've had in mind so far. The COVID-19 vaccines are a spectacular example of science in action, but also of government industry participation. After all, government funding here and at academic institutions across the world helped bring this great innovation forward. And it's a good reminder that patents are not the only important way that governments can promote competition. It's important for us to have government funding and increase government funding for basic research, but also to provide incentives for all students in elementary school to graduate school to enter science careers. Our future really depends on those types of initiatives, not just the patent system.
The time of the
very much.
gentleman
I
has
yield back.
expired. Yields back. I now recognize the distinguished ranking member of the Antitrust Subcommittee, Mr. Buck, for 5 minutes.
Thank you, Mr. Chairman. I take it I'm on right now.
Yes, you are, Mr. Buck.
Thank you. Professor Daphne, I want to direct these questions to you, and it really is a follow-up on questions that Congresswoman Jayapal asked. I have noticed in the nonprofit area of hospitals that the salaries for top executives are, in my view, excessive. When I think of a nonprofit, I think of the United Way. I think of gun rights groups, gun control groups. I think of environmental groups. I think of private property rights groups. And they rely, for the most part, on fundraising for their revenue stream, sometimes on government grants, sometimes on other programs, but oftentimes on fundraising. And when there are issues, and there have been, I think, with United Way a few years back, where there was an allegation of excessive salary or benefits or expenses, and I know there was recently with a gun rights group also. The funding source sort of dries up. The fundraising is more difficult, if you will. And that's not the case with hospitals. For the most part, hospitals, I know of some hospital benefit events, but for the most part, hospitals receive revenue from the services that they provide. And I'm wondering if there is a way for the Antitrust Subcommittee to look into this area as one of the rising costs and resulting costs for healthcare in this country. I have to tell you, when the CEO of Apple or the CEO of Microsoft or the CEO of other companies make a lot of money, I'm okay. They have a board of directors. They have a profit incentive, and there is some downward pressure on their very high salaries. I don't know that there is in this area, and I just want to get your thoughts. As a small government conservative, I don't want a regulatory agency overseeing salaries for hospitals or other healthcare entities, but as a taxpayer advocate, I also don't want to see a lot of taxpayer money going to pay costs when these folks are making so much money. And any thoughts on that?
Just briefly, thank you for the question, Representative Buck. I'm not familiar with any statutes that might restrict the compensation. I would add the compensation for executives at nonprofit insurers are quite high. And I would say that just as is the case with with regular for-profit businesses, it's about the boards. And if the boards, they have compensation committees as well, are benchmarking against other similar CEOs, they approve the salary, then that's kind of what the market price is for someone with that skill. I would say that the enterprises are very large, in the billions of dollars. So personally, my concern lies more with what the total amount that is being charged is ending up and less with the specific compensation of the executives that belong. But I would say that they ought to be touchable by state enforcement of, community benefit laws.
Yeah, so often boards of directors are appointed by the, or at least recruited by the former boards of directors or the high-ranking executives. And so often,
Therein lies a governance problem, right?
yeah, and so often in these areas, the high-ranking executives are treated like the shareholders in a for-profit company. The excess revenue is distributed to those at the top of the organization, and it's very concerning. And you raised insurance, nonprofit insurers, and I'm not trying to pick on the hospitals, but it just seems like there has to be some mechanism to try to keep those salaries in check so that we have a more responsible expenditure of federal funds. And I would love to talk to you offline about this. And frankly, Mr. Chairman, I'd love to have a dialogue with you also on this issue, because I think it really goes to the cost of healthcare, part of the cost of healthcare in America. And I yield back.
Absolutely, Mr. Buck, and I look forward to our ongoing discussion on that really critical issue. This time, I'll seek unanimous consent to add a number of letters and statements regarding the committee's work to address anti-competitive conduct in healthcare markets. A statement from Kristen McGovern, the Executive Director of the Partnership to Empower Physician-Led Care. A statement for the record from George Slover and Sumit Sharma of Consumer Reports. A statement for the record from the Purchaser Business Group on Health. And a statement for the record from Marnie Jamison Carey, Executive Director of the Association of Independent Doctors, without objection. Before I close, I just want to say thank you again to our extraordinary panel of witnesses for your testimony that I think really helped to inform the work of this committee and will allow us to really make some progress on reducing the cost of prescription drugs in this country in a bipartisan way. So with deep gratitude, I thank you for your presence here today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is hereby adjourned.